developments in the medico-legal circle. There have been new provisions in the Consumer Protection Act, and majority of us want clarity where we doctors stand. For this, we have today eminent and learned speakers with us who shall share the intricacies of the new provisions of the Consumer Protection Act. Dr. Muralidhar Joshi, President ISA National, Dr. S. Balabhaskar, Chairman Academic Committee ISA National, Dr. Venkat Giri KM, President-elect ISA National and coordinator of today's webinar, and the esteemed invited faculty, Dr. Rajan Sharma, President IMA National, Dr. Ashok Patil, NLSIU Bangalore, Dr. SM Kantikar, member NCDRC New Delhi, Dr. Sunila Sharma from Gurugram, our expert in medical legal issues in anesthesia. A warm welcome to all the faculty. Dear friends, ISA National has started more than 20 programs, and one of them is ISA Legal Cell. It was formed in the year 2019 with the basic vision of guiding our fellow anesthesiologists in the hours of need and medical legal issues. It comprises of those anesthesiologists who have legal background and understanding of law, and they are from all over the country from different states. ISA National is soon going to expand the ISA Legal Cell. All of those who are interested to join ISA Legal Cell can contact me personally or by WhatsApp or by to isanhq@gmail.com. I now request President Dr. Muralidhar Joshi to formally inaugurate the webinar and advise us. Dr. Muralidhar Joshi.
Good morning, everyone, and I'm sorry to trouble you on a Sunday morning. As usual, we have some discussions quite important. Respected Chairman Economic Committee, Dr. Balabhaskar, President-elect Dr. Venkat Giri, our Honorary Secretary Naveen Malhotra, and our Honorary Treasurer Virendra Sharma. Of course, our esteemed faculty, Dr. Ashok Patil from Bangalore, and Dr. Kantikar sir from Delhi, and also Dr. Sunil Sharma from Gurugram. So, madam, it's nice meeting all of you in the morning. It's quite pertinent. I really don't know, because it's very important for ISA point of view. The reason being, if you just look at the legal implication, the two medical faculty who pay the highest amount of what you call it as the professional indemnity insurance, it happens to anesthesiologists and the cosmetic surgeons. These are by and large across the globe. These two specialties pay the highest amount of the what you call premium for the whatever kind of professional indemnity insurance. But unfortunately, both the units get into problem. Now sometimes government interprets ours as a public service should be exempted from all kind of liabilities of this legal thing. And sometimes they say you are a commercial establishment. Now we are caught with devil and see. We really don't know. Sometimes we think like this, but again, in the court of law also judges sometimes this way, that way. And again, whatever the new amendment which has come, again, experts keep on interpreting sometimes this way, sometimes that way. We really don't know where do we stand. If you have to be service, then let's be service. If you are commercial establishment, then you provide all the things, establishments, whatever things you provide for whatever medium, what do you call it, micro, small or medium, small industry, whatever benefits you provide for the industries, you provide discount on the land, discount on the building, discount on the power, discount because we are developing a business. If we say medical profession is not business, if it's service, then exempt from all these things. Give the land at the free of cost and give all these things subsidized. We don't know. Sometimes you say this, sometimes you say that. We really don't know. I think we have the best excellent faculty over today. I think Dr. Ashok Patil and Dr. Kantikar and Dr. Sharma should take us through and clear this dilemma, because what is happening, sir, also madam, this called consumer thing is what is happening is it's like uncharted territory, and the people, doctors who are sitting, especially in general practice, and they're being beaten on the streets. This doesn't speak of a well-civilized society. What is happening finally is the doctor who was doing consultation for 10 rupees is disappearing. And nursing homes which are doing probably the season sections for about 3,000-4,000, they are disappearing. So finally, you end up with centers of excellence which are ivories of tower, and then you say the cost has gone up. Who made the cost to go up? These are the things probably all the medical fraternity across the country we are thinking about it. What are we? Where do we stand? Are really I don't know sometimes what to say, like children of lesser god kind of thing. That's what we feel sometimes. And I think in this context, we want expert advice also. Does what you have the administrators with respect to ISA and I should say about IAS and then IPS and IFS should be an Indian medical service that I want you people to address. And third thing, and we are more of an orphan child like Indian archaeological, what are the bodies there? Because the railway force has its own railway protection force, police, and so is the regular police, except for archives department, where all the monuments are exposed because anybody can do the vandalism over there, and they can magazine report to local police. We are like that. I think the medical fraternity and the archaeology fraternity are in the same boat. Please guide us what we should be doing, how we can go about it. With these opening remarks, request Dr. Venkat Giri, President-elect, to conduct the rest of the session. Morning, Dr. Venkat Giri, please go ahead.
Good morning, everybody. President Dr. Muridhar Joshi, Secretary Naveen, esteemed faculties, my good friend Dr. Kantikar, Professor Ashok Patil, and Dr. Sunila Sharma. Good morning to you all. We were all thinking that because the newspapers report and IMA report, everything came that doctors are exempted from the CPA, the order will come and all with the parliament statement by the minister and all. But we were shocked when we saw the Gazette notification 2 weeks back stating that doctors are not exempted. It is. So I was also wondering and we were worried. We were conducting regularly our CMEs on medical field. Then we thought that yes, our members were thinking that we are not there, and what exactly, what are the changes? Are there any benefit for us, anything detrimental or anything like that? She wanted to have a webinar on this. So I was conducting regular webinar for the Kerala, and I thought that we will have one, and the best person to contact me was Dr. Kantikar, with whom I did PG Law in National Law College, Law School of India University long back. So we are in touch since that time. Then he advised, Giri, yes, you can go ahead. And Dr. Patil is there, who is the chair of the consumer law in the National Law School. I will talk to him and make this. And we thought that Dr. Naveen told that Giri, we will have a national webinar and with the good audience, is a good subject. And that's how we conceived this webinar. And we are having a national webinar. We have good faculties for this webinar. Naveen, can we share the slides?
Thank you, Dr. Giri. And we have got Dr. Rajan Sharma also, President IMA National with us. So before we start the lectures, and after the lectures, we will have panel discussion and question and answer session where we'll go live again. So I'll request Dr. Rajan Sharma to say a few words. I know you are driving. Dr. Rajan Sharma, please.
Good morning, Naveen. Good morning, everybody.
Good morning.
Pertinent topic which you all are discussing. So let me share the perspective that in the last session of the current government's last term, we could manage to get healthcare services excluded from the consumer services. As it is, this is the official point at the moment. But yes, we are not out of it. And IMA is already taken legal opinion, and we have already started mobilizing the government on this issue. And I have had a few meetings already with the central government. So still keeping all our options, legal options, which I know on the entire country, my medical fraternity colleagues are quite perturbed about the CPA, and including me also. I'm also one amongst you. So don't ever think we are moving our steps, but yes, our problems are that we cannot publicize everything. And option of legal help will always be there. And whatever the deliberations you decide, I would request Naveen to share it with IMA so that we have a common platform where all of us brainstorm together and put up a joint effort, because we cannot be seen in isolation as various associations, and we have to work in unison to take on this menace of CPA. But also, alternatively, you also have to think of a mechanism where we are out of CPA, but the patient interest also has to be seen by some medical commission or whatever it is. Because if you remember, when originally we were not in CPA, but when the Supreme Court case came, they only asked the current office bearers that time that do you have a redressal mechanism for patients, to which we had flatly refused. The patient cannot have any grievances against a doctor. So maybe we have to think in house, and we are the best of brains. If we can save lives, we can definitely come out with a very viable solution to this. And I wish you all the best. Thank you so much.
Thank you, Dr. Rajan Sharma, and we'd like to have you after another 45 to 60 minutes, after 20 minutes of free talks. And now
Sure.
I invite the first speaker, Dr. Giri. Please introduce the first speaker.
Naveen, you have the slide with you, or I should?
The speakers have got the slides with them.
No, their introductory slide, their CV slide. I have made and sent you. Otherwise, I will.
You should project from your side, sir.
Slide share, if you allow, I will do that.
Yeah, it is allowed, sir. It is allowed. Bharat, please help Dr. Giri.
I'm not seeing the slide share in this.
Doctor, it's at the below share screen option, please.
Yeah, okay. All right. Okay. I have opened it. I have to click share and
You need to click share screen and a pop-up will appear. You need to share screen again.
yeah, again, okay, screen. Okay. Yeah, right. Good morning. It is my pleasant duty to introduce my good friend, Dr. S.M. Kantikar, who is a medical man, a pathologist who was practicing pathology in Shivamogga, and he later did a PhD in law from National Law School, Bengaluru. He was running a pathology lab in Shivamogga, and he was a director and a consultant for two medical, two blood banks in Shivamogga, that Rotary Blood Bank and Red Cross Blood Bank. Later, he became the member of Shivamogga District Consumer Redressal Forum for one term from 2003 to 6. And he then joined in the Department of Pathology at Shivamogga Institute of Medical Sciences, the Government Medical College Shivamogga, and worked there till 2013. And then he joined National Commission for Consumer Dispute Redressal. And now he is continuing in that position for the second term. He is a resource person for medical law, medical negligence and consumer laws in National Judicial Academy, IIPA, IIT, and IIMA. His research subjects were Impact of Consumer Protection Act 1986 on medical negligence, the right to health, human perspective, and legal regime. With this brief, I present to
Dr. Giri, Dr. Ashok Patil also is the first speaker. Introduce both of them.
Okay, right. Then next, I would like to introduce Dr. Ashok Patil. Okay. Next slide. I have to go back and change Bharat. This slide I have to close and.
Doctor, you can just close this slide and open the next one.
Okay. Dr. Ashok Patil, who is the professor of consumer law in National Law School of India, University of Bangalore. He did his BSc Criminology, LLB, then LLM and PhD in law. He is currently the professor of Consumer Law and Chair of Consumer Law in National Law School of India, University of Bangalore. He is a recipient of the prestigious Asian Law Institute Fellowship in 2010 and Legal Education Innovation Award in 2013. He is the chief editor of International Journal of Consumer Law and Practice. Formerly, he was a practicing advocate in Karnataka High Court and then joined as a lecturer in Karnataka Keli Society's V.V. Bellad Law College, Belagavi, and became its principal. He joined National Law School in 2008 as associate professor and became professor. He has visited more than 15 countries and organized more than 40 workshops. His articles are published in national and international journals, and he is chair of the mediation in National Law School, and he has made the workshop online mediation and other things. So he's well versed with these things and consumer law. He was a member of the 2015 and 2019 Consumer Protection Act amendment. So he knows the in and out of it, and he is the best resource person. He was the teacher of our first faculty, Dr. Kantikar. With this, I request Professor Ashok Patil, who is teacher of the our speaker, Dr. Kantikar, because I asked Kantikar, is there any protocol? Because he told us, Giri, he is my teacher, don't see any protocols. Let my teacher talk first and I will talk next. So it is Sunila, I will introduce her later. So we will go for, she's our own member anesthesiologist. So I will make the guest first and then I will introduce her. Over to you, sir, Dr. Ashok Patil, sir.
Thank you, sir. Kindly allow me to share my screen.
Bharat.
Sorry, just a minute.
Doctor, can you make it slide?
Yeah. Okay. Is it visible?
Yes, sir.
Yeah. Respected, at the outset, my sincere thanks to the organizers, Indian Society of Anesthesiologists, and all the office bearers, Rajan Sharma, Muralidhar, Sunila Sharma, Venkatagiri, Naveen, and respected Kantikar, member of National Commission. Before starting my presentation, first of all, let me put on record, I respect doctors, hospitals who are working hard during emergency time without hesitating any type of a problem with a risk they are involving. So with great respect, I'm starting my presentation. So this particular Consumer Protection Act enacted in India because United Nations come out with the guidelines in 1985, UN guidelines on consumer protection. UN guidelines on consumer protection in 1985. India is the first country adopted those broad guidelines and enacted a Consumer Protection Act 1986. In India, it's not a new thing. Even if you look into our Mahatma Gandhi's statement that customer is the most important visitor on our premises. he is not dependent on us. We are dependent on him. He is not an interruption on our work. He is the purpose of it. He is not an outsider on our business. He is a part of it. We are not doing him a favor by serving him. He is doing us a favor by giving us an opportunity to do so. So this is the statement given by father of the nation. And okay, as I've said, it's not a new to Consumer Protection Act to India. Even Kautilya's Arthashastra, chapter 2 in book 4, removal of thorn chapter, in detail they have given how during king's time exploitation happened and king used to control. Under the constitution, see, we governed by constitution. Everybody in India governed by constitution. No one is exception in India. Constitution is the supreme. So whatever fundamental rights are given under the constitution, that has to be protected by the state. So this is Article 19, Clause 1G, right to freedom to carry on business or trade. So it's a fundamental right given to everybody. But at the same time, it is not an absolute fundamental right. That's why under Article 19, Clause 6, state can impose reasonable restrictions on trade in the interest of public. So state has a power to impose reasonable restrictions in the interest of the public. Then Article 21, right to life with dignity. Even though it's a one-line article, but it covers a lot. And right to life with dignity means without exploitation. It's the state duty to guarantee that everyone in this country has a right to live with human dignity and is free from exploitation. So this is the particular fundamental rights chapter, and there are two directive principles. So this particular directive principle, Article 38, state to secure a social order for the promotion of welfare of the people. Then Article 47, duty of the state to raise the level of nutrition and standard of living and to improve public health. It is a directive principle. So because of all these fundamental rights and directive principles, it is the state duty to protect the people of India from any type of exploitation. In India, under the Consumer Protection Act, one national commission, around 35 state commission, every state has a state commissions, and around 629 district commissions. Now it is called as a district commissions under the new legislation. Background, why India thought of amending this 33 years old legislation. Government of India, Ministry of Consumer Affairs, working on this matter since 2010. It's not a 1 year or 2 years they thought and enacted this law. No, they worked on this since 2010. I'm heading a consumer chair of Ministry of Consumer Affairs, Government of India since 2008. I know how they have conducted the program. Many in all the directions of the state, they conducted all stakeholders program, and they took all the inputs and they gone ahead. And there are two national surveys done by the Cuts International in 2012, and another national survey done by Indian Institute of Public Administration in 2013. And there is a very landmark judgment of a state of UP and others versus all UP Consumer Protection Bar Association. So that particular judgment discuss overall how the consumer redressal commissions are working, and what are the infrastructure, what is the salary, all those things together comprehensively they looked into. The Supreme Court, with a 3 judges bench, they constituted a committee under the Justice Arjit Pashayat with the 2 other members. And this committee visited all the states, met all the state commissions, district commissions, NGOs. They got all the informations and submitted a report to the Supreme Court. One part of it was about the qualified, merited people are not coming to the district consumer forum because of not reasonable or reasonable salary to them. So that's why Supreme Court constituted a committee, directed central government to constitute a committee to frame rules for the appointment of the members and salary and other perks. So in that regard, central government constituted a committee. I was also one among them. We framed the rules, regulations, and the reasonable salary package, all those things, and ultimately submitted a report to the Supreme Court, and Supreme Court sent to all the state chief secretaries to adopt. Same those guidelines which are sent by the Supreme Court now under the rules now under 2020. Other aspects, a lot of things are discussed in that judgment, how the redressal machineries are working. Then in 2010 to 2013, during Congress time, the government thought of amending the existed Act 1986. They don't have an idea of coming out with a new legislation. Whatever loopholes were there under the 86 Act, they wanted to amend. Especially e-commerce, electronic media, electronic platforms are coming, and other aspects they considered. And another one is execution powers. Enforcement power should be given to the consumer forum, just like a regular court has a execution power. So these are the some areas where they wanted to amend. But during that time, I know around 2011 one bill was there, amendment bill, and around 2013 one amendment bill was there. But ultimately it was not moved ahead. During that time, Congress government gone and BJP government came. And then BJP government ministry thought of a lot of amendments are needed. Instead of amending every section, better we should go for new legislation on Consumer Protection Act. That's why they designed, again, they conducted many programs, called people for their inputs, and they came out with the Consumer Protection Bill 2015. And it was on the public domain, comments, they received all the comments from all the stakeholders. And when it was introduced in Lok Sabha, then Lok Sabha appointed a standing committee to look into the 2015 bill. Again, around 20-25 MPs of all the parties sat together. They invited all the experts throughout the India, and they took their review, the expert opinion, and ultimately they submitted a report to the parliament, then to government. Again, that 2015 was reviewed. Then whatever inputs were there considered, and CPA 2018 introduced. And during that time, again, election announced, it was lapsed. It was a CPB, CS, Consumer Protection Bill 2018, it was lapsed. Then came 2019 CPA, Consumer Protection Act 2019. And in 18, there was an international conference which conducted in New Delhi. United Nations experts were invited. Again, at the national level, all the stakeholders invited in that particular conference discussed on different topics. Then the outcomes are also considered. So ultimately, on that basis, CPA 2019 came into force. So it's not a 1 year work or 2 years work. Since 2010, the government is working on this. Then it was, even though it was notified in 2019 whole legislation, but there was a clause. The central government has to notify on section wise or chapter wise. So that's why ultimately it has notified in 20th July some portion, and 24th July rest of the portion notified. Now, as on now, every section is notified and come into force. Now it is in force. The background representation of the aggrieved consumers. This is a national survey done by the Cuts International. The law is enacted to help because in regular court, lot of delay was happening. Both parties were suffered. So that's why summary in proceedings, party in person, less expensive court fee, all those things imposed. Intention is party in person come and argue, but the things are not happening. Advocates represented around 89%. So that also they looked into how best we can simplify so that the party themselves can come and argue their matter. So that was the one of the outcome. And even though the court's consumer forum says within 3 months, Consumer Protection Act says the within 3 months case has to be disposed of once the notice served to the opposite party. In case of lab test is needed 5 months, but it was not happening because of these reasons. Even though central government enacted law, but ultimately state government to implement those central legislations. But the central government not that much given importance. That's why the delay has happened on many grounds. One is adjournment sought by advocates or parties, lack of administrative staff, etc. So this is also one of the reasons they have considered how best we can quickly dispose of the consumer cases. And another IIPA New Delhi's survey, around 28% of the cases are settled within 5 months. But 72% of the cases disposed of after 5 months. So that is another reason they have introduced how best we can settle. That's why mediation chapter introduced in the new legislation. So these are the new rules under the Consumer Protection Act: Mediation Rules 20, Mediation Regulations 2020, E-commerce, Central Consumer Protection Council rules, then Central Dispute Redressal Commission rules, general rules, salary and allowance for the members, qualification of appointment. All these rules are notified and now all are in force and state governments have to adopt. In new comparing how the 86 Act 2019 Act different from 86 Act, 3 new chapters are added. One is Central Consumer Protection Authority. Next one is a mediation. And the third one is product liability. These are the new 3 chapters which were not there in 86 Act. And whatever words used in these chapters, those words definitions are given in the definition section. This Central Consumer Protection Authority. So this authority, actually when 86 Act was introduced, there was a MRTP Commission, MRTP Act, MRTP Commission. And because the MRTP Commission used to take care of all UTP unfair trade practice cases or restrictive trade practice cases between consumer and the manufacturer or service provider, that's why government not thought of establishing another central authority under the Consumer Protection Act. But later, this MRTP Act repealed and Competition Act came into force. And Competition Act and Competition Commission, they are hearing only B2B unfair trade practices or cartel system, B2B, business to business. They are not hearing the consumer to business cases. That's why government thought of establishing independent redressal system under the Consumer Protection Act. And here under the Act, Chief Commissioner is appointed. Under Chief Commissioner, many additional commissioner, deputy commissioner, and director general who has a power of suo motu, taking cases and investigating powers. So full-fledged central authority is established, because the commission, the district commission, state commission, national commission, they don't have investigating powers. They don't have suo motu powers. They have to hear only when case is filed, otherwise not. So that's why these central authorities will look into major part of unfair trade practice, restrictive trade practice, where whole mass is exploited by the manufacturer or service provider. So they can take actions under that. And if anybody aggrieved by central authority, they can file an appeal to the National Commission. So that is about the central authority. Next is mediation, because delay was happening because of the reasons which I have mentioned in earlier slide. To avoid that, if both parties are ready to settle the matter outside the consumer forum, let them settle. So now every district commission, state commission, national commission will be attached with a mediation cell, and the commission will appoint the mediators who are skilled person, who can be appointed as a mediator. That is given under the regulations 2020. Those people will be appointed to settle the matter. So here, instead of if party is ready, then even the party may not take the advocate along with him. Party himself sit and settle the matter with the service provider or manufacturer. And if it is settled, and then the even paid court fee by the complainant will be refunded. So that is the benefit for the complainant. So mediation is the best method at this stage to settle the matter. If there is a genuine case, settle the matter through mediation. And or see, another very important thing in mediation, it's a confidential. So whatever you are discussing, everything will not be narrated in the judgment. Only one page, both the parties for agreed for what. So those terms and conditions, those points will be put in the mediation. Both parties will sign and mediator will sign. That document will be submitted to the Consumer Commission, and they put a seal on that particular mediation decision. And whatever you have discussed in the mediation, whatever you have explained, whatever documents you have given, that will not be coming on public. So that will be with you only. That is the benefit of keeping whatever issue has happened, problems are happened, it is not in public domain. But if it is come to the consumer forum directly, or the case is not settled in mediation, then comes back to the national commission, then commission will take its own procedure as per the Consumer Protection Act. They have to write what the complainant said, what defendant opposite party says, what documents they submitted, everything they have to write, and at the end they have to give decision. That is a public document, everybody can access that. Then coming to product liability chapter, new chapter, again, product liability, it is connected to many other sections of existed defect or deficiency or other aspects, also manufacturer. So it is related to the product. So that the manufacturer or the concerned person, seller, whosoever responsible for that particular injury or defect, so that person will be held responsible. So these are the new 3 chapters added. Under the consumer definition, already you know the who is a consumer, whosoever hires a service or purchases goods for consideration, except for commercial purpose or resale purpose. So that person is a consumer. So they have added another clause in that anybody hires or avails any service, includes offline or online transaction through electronic means. So now the government kept in mind what is happening at the international level and national level. The market is changed. A lot of online trade or business or services are happening. So to clarify that, they have added the transaction, online transaction through electronic means. Another very important section is definition is deficiency. They have not touched the 86 Act definition in first paragraph. They have added two clauses, 1 and 2 at the end. Any act or of negligence or omission or commission by such person which causes loss or injury to the consumer. Any act of negligence, omission or commission by such a person which causes loss or injury to the consumer. Second point is very important. Deliberately withholding of relevant information by such a person to the consumer. Actually, that is very important information which should be shared to the consumer, but the manufacturer or service provider knowingly it is important. If they withhold that information, then it is considered as a deficiency under the new definition. So other aspect, goods, they have broadened the definition goods. Earlier goods as per the Sale of Goods Act. Now every kind of movable property, even including food, is considered as a the goods. And then unfair trade practice. Unfair trade practice is another definition they have added. Not issuing the bill or cash memo or receipt for the goods sold or services rendered in a such manner as may be prescribed. So unfair trade practice includes if any manufacturer or service provider is not issuing a bill or cash memo or receipt is considered as unfair trade practice. Another one, refusing after selling goods or rendering service to take back or withdraw defective goods or discontinuing deficient service and to refund the consideration thereof if paid within the period of stipulated in the bill or cash memo. So that is also unfair trade practice. Then disclosing to the other person any personal information given in confidence by the consumer. So as a consumer, he has shared his information with the manufacturer or seller or service provider. If that information shared with a third party without approval or consent of the consumer, that is also unfair trade practice. Then about the advertisement, because nowadays a lot of advertisements are coming. There is no control by the regulatory authorities. So that's why now they defined what is advertisement. So whatever form of audio, visual or representation or endorsement or pronouncement, any type of thing through light, sound, smoke, gas, print, electronic media, it covers everything. So that is defined under advertisement. And endorsement definition was defined even when when it was introduced in Lok Sabha and Rajya Sabha. A lot of questions are asked, and Honorable Minister replied for every provision why it is added, all those things. Even on endorsement, Jayaprada asked questions and he explained why we are adding that. There is a video, you can see that particular video to understand how it was discussed. So endorsement in relation to an advertisement means any message or verbal statement, demonstration, depiction of the name, signature, likeness, or other identifiable personal characteristics of an individual, depiction of the name or seal of any institution or organization, which makes the consumer to believe that it reflects the opinion, finding, or experience of the person making such endorsement. Public is believing some people, some institutions. They believe that if that particular institution says 1 + 1 = 3, they believe that. So to that extent, that institution has a credibility. But if in 1 + 1 = 2, they believe that that is correct. 1 + 1 = 3, what they are saying, even though it is wrong, they believe that it is correct and they enter into contract. That's why institutions a reputed institution should be very careful when you are endorsing anything, unless the scientific way it is proved, lab test is there, then sample, the survey is made, big sample, scientific sample is used, and that particular survey recognized by the government institute and funded by the, again, funding of that survey is very important. So all those things are looked into. That's why looking into all those facts, the endorser should decide I should do it or not, because they ultimately, if anybody files a case, jointly and severally responsible. Then misleading advertisement is also defined. In relation to any product or service means advertisement which falsely describe any product or service, gives false guarantee, or likely to mislead the consumers as the nature, substance, quality, quantity of such product or service, conveys an express or implied representation which, if made by the manufacturer or seller or service provider thereof, would constitute unfair trade practice, deliberate, conceal important information. So this is the misleading advertisement. And other aspect, punishment for false or misleading advertisement. Service provider who causes false or misleading advertisement to be made, which is prejudicial to the interest of the consumers, the punishment is imprisonment for a term which may extend to 2 years, and with fine which may extend to 10 lakh. And every subsequent offenses, the punishment increases. Another new definition added, unfair contract. I'm not going in word to word, just I'm giving you the gist so that we can cover more. So unfair contract definition was not in 86, now they have added. So there are 6 points they have given. Asking excessive security deposits from consumer, especially banks while giving a loan, they do that. Then imposing any penalty on a consumer if a breach of contract happens, whatever losses happen to the opposite party, to that extent they can impose penalty, but disproportionate penalty will be put in the contract. That should not be accepted. Whatever loss has occurred, yes, that has to be paid, but not more than that. Refusing to accept early repayment, again it happens in banks. The early payment, if they are taking, then they put a penalty on that. Then contract to terminate such a contract unilaterally without reasonable cause. So if any contract is breached without any reasonable cause, or unilaterally terminated, then that is also unfair contract. Imposing on consumer any unreasonable charge or obligation or condition which puts such consumer to disadvantage. This is another very new point. Imposing on the consumer any unreasonable charge, obligation, or condition which puts such consumer to disadvantage. So all these points are considered or looked into depending on each case, facts, and circumstances. These are not a concrete definitions, but it will be interpreted looking into the each case, facts, and circumstances. Jurisdiction of the district forum. So earlier, up to 20 lakh pecuniary jurisdiction was there. Now they have increased to 1 crore. And another point, they have added the complainant, whatever CPC provision was there, they have added in the territorial jurisdiction under the Consumer Protection Act 86. So they kept the 86 definition. They have added another one, complainant, where complainant resides or personally works for gain. So here the intention behind this adding this particular clause, because especially whoever looking into the Indian population, looking into the Indian variety of people, especially the poor consumer, if he is in taluka place, he has to go to that particular place and file a case. And because of that, a lot of cases are not filed, even though they have aggrieved. And even in national survey, if you look into that, only 0.3% of the aggrieved consumers filed a consumer complaint in past. So that's a 2012 national survey, clearly mentioned only 0.3% of the aggrieved consumers approached consumer forum. Most of them, they have aggrieved, but they have not filed because of many reasons. So one very important reason was why I should go to that place and I have to spend money, and whatever what I'm claiming is lesser than what I'm spending on this case. So a lot of other issues were discussed, and that is decided. And another thing, anyway, there was a clause, cause of action, where cause of action arose partly or fully. So that also take place any place in India where cause of action partly or fully arose. And another clause was there under this particular act in 86 itself, any branch office. So there also they used to file. So this is the additional thing they have added, looking into the situation and background or survey on that. Procedure on admission of complaint. So they throughout the legislation, they gave importance to the digital media, digital age. So electronic services are recognized. So a lot of cases are delayed because of notice are not served. Now electronic service provider, electronic services will be considered. And there are people who are very serious in their business, or they don't have a time to attend. Then video conferencing facilities are made for them. So sitting in their place, they can give their evidence through video conference. So that provision also they have made. Review powers are given to district commission. Earlier it was not there with the district commission. So district commission shall have the power to review any of the order passed by it if there is an error apparent on the face of the record. So if that is the case, the party, aggrieved party can file a review before the district commission, similarly with the state commission or national commission. So there itself, it will be corrected. Appeals, district commission to state commission, which is discussed in section 41. Within 45 days, it has to be filed, and appellant has to deposit 50% of the order of the lower commission. And another clause is added: if the mediation, if case is settled through mediation, no appeal is permitted. If in district commission, the dispute is settled through mediation, no appeal to the state commission. And this is 50% of the order, whatever the order is given by the district commission. They looked into past the experience and what they thought. It is not 50% of the claim. Always claims are higher. But looking into the merits of the case, district commission's orders reasonable compensation. That particular orders 50% has to be deposited. And another idea behind it is to unnecessarily filing appeal. Always the other party is a stronger party, seller, manufacturer. So financially sound also. So usually some of the cases went up to National Commission, Supreme Court without any merit. They went. So it is, if it is a genuine case, then only they file appeal. Otherwise, they stop there itself. And another reason is, even though they are depositing 50%, if you deposit 50%, not mean that that 50% amount gone. If you win the case, that amount will be refunded to you. So it is not only for the convenience purpose, only for if there is a genuine case, then only appeal should be filed. So for that purpose, with that object, it is included. Even though the opposite party deposited 50% amount, that is your money in the higher commission. But ultimately, if you win the case, that amount will be refunded. So that amount is safe. There's no problem in that. And coming to the service definition, what I observe, whatever discussion is happening, MCA, Medical Council of India, or doctor fraternity on this particular definition, as I understood, I may be wrong, but what I understood. See, this service definition is not an exhaustive definition. It is an inclusive definition. Service means service of any description which is made available to potential user and includes but not limited to. You just concentrate on these words. Includes but not limited to. Here they have given some examples: banking, finance, insurance, transport, processing, electrical, telecom. All these some examples are given. The words which are not used in this section also covered, because it is not an exhaustive definition, because it says includes but not limited to. Only exception is rendering of any service free of charge or contract of personal service. These are the only two exceptions. Other than that, even I think what has happened when it was in 2015, it was, see, 86 Act was also same. 86 Act, no, the definition was same. Only I hope in 2015 bill or 18 bill, they have added health service in these examples. Health service in these examples. Later they removed by adding, assume that health service added or not, immaterial. Immaterial because it includes but not limited to. So by dropping that health service from this definition, maybe they think that it is not covered under Consumer Protection Act, but the definition itself says includes but not limited to. Even though any services which are given for consideration are covered, there is no exception. Under this act, there is no exception, because if there is an exception, that has to be made at the beginning. The object of the legislators is clear. So whosoever hires a service, whosoever purchases a goods, everything is covered under this particular legislation. There is no exceptions to anything. Then appeal to National Commission. Earlier, unnecessarily, they used to file a appeal to National Commission. Now, only those cases which are having substantial question of law is involved, only those cases can be filed appeal. Otherwise, State Commission is the end. The National Commission will not admit those cases which are not on question of law. Then jurisdiction of National Commission, if and then earlier existed 86 Act was continued, added another one, appeal against the Central Consumer Authority. So that is added in this particular jurisdiction of National Commission. And another very important thing which was needed, administrative control. National Commission can control all state commissions. All state commission can control on district commissions. All types of administrative control. And now National Commission has a investigating power. If any allegation against the president or members of the state commission, then the complaint can be filed to the National Commission. National Commission will do the investigation and submit a final inquiry report to state government to take necessary action against the concerned member or president. And also the National Commission will have a monitoring cell constituted by president, oversee the function of state commission from the administrative point of view. So this is also taken. So all comprehensive view has taken in this particular new legislation. Another loophole was there in the 86 Act. The final order of the district commission or state commission, national commission, they don't have a power to execute their own order. So that was the loophole. That's why the consumer more times they used to section 27 than section 25 of CPA 86. Now the full power is given to district commission, state commission, national commission. They can, once the order is given, final decision is given, then the as if it is a decree of a civil code, they can execute. So I'm running out of time. I will quickly finish it. Penalty for non-compliance of order. Whoever fails to comply with any order made by District Commission, State Commission, National Commission shall be punishable with imprisonment of 1 month to 3 years, or with fine to 25,000 to 1 lakh. If, without filing appeal, if they are not fulfilling the order, then section 1 or 2, power of state governments to make rules. Here, this particular, actually, it's a power of state government, but until the state government makes a rules, central rules are applicable. And even though state makes a rules, then that should be practicably similar or conform with the central model rules. And all these things, ultimately, it depends on the Supreme Court, lot of judgments, access to justice concept. Supreme Court held that access to justice is a fundamental right and laid down 4 main facets of the essence of access to justice. So it is a fundamental right of every citizens of India. What are those 4 essential elements? The state must provide effective adjudicatory mechanism. The mechanism so provided must be reasonably accessible in terms of distance. The process of adjudication must be speedy. And the litigants' access to the adjudicatory process must be affordable. Because of all these things, ultimately, the Supreme Court, it's a constitutional bench. So every ministry is working towards the main constitutional, the object, access to justice to the aggrieved people. So with this, I conclude. Sorry for taking more time, because unless we understood what are the new changes compared to 86 Act, the discussion will be more fruitful. Thank you very much. Over to you, sir.
Thank you,
Now
sir.
I invite
We'll have the question
Dr.
answer at the next session, sir.
Yeah.
Now it is over to Dr. Kantikar for his presentation. Bharat, Kantikar, screen sharing and.
Yes. Good morning, everyone, and thank you for the invite. And thank you, my professor, Dr. Patil, who highlighted all the new features of the new act, because there is a lot of confusion amongst the doctor, medical fraternity about the services, doctor services and other. He has covered everything, and he made my task very easy. Today, I will start with the consent. No, it is just a minute. I will start from first slide. So you have assigned me one topic, legal implications.
Doctor, can you share your screen, please?
Yes, it is.
No, we are not seeing.
1 minute.
Just
a minute. Where I am stuck, I don't know.
First open it, then ask for click on screen sharing.
Yes.
First open that thing. Yeah, now it is coming.
Now it is.
Yeah. Computer, you open the
I'll open
PPT. PPT, yeah. Okay. You enlarge that.
Yes.
Perfect.
Okay. So consent is very important topic in our medical practice, whether is it anesthesia or any branch of the medicine, consent is very important. And since 1950, the notion of reasonableness, you may be aware how the medical negligence is decided. It is decided on the reasonableness. The notion of reasonableness has been critical in the process of informed consent. So just I will share my experience in the National Commission, where we decide many cases. And I want to say many of the doctors, why they are penalized because one is they are not maintaining proper record, and most of the time there is no proper consent also. So with this, we'll start the presentation. What is consent in the medical practice? Consent is required by the law. You know, it is for the patient's autonomy. Patients have every right to decide what happens to their own body. You don't have, anybody has no right on others' body, especially doctors when at the time of examination or any investigations or invasive procedures, surgery, you are anesthetist, this association is anesthetist, or your role in the consent is very important. Pre-anesthetic checkup is there, and you have to explain the drug reactions and many of the anesthetic complications and what not, and what will happen if I use this anesthesia, or there are a number of different types of anesthesia. You can have a discussion with the patient. Now it is for the patient's autonomy. Then it is essential prerequisite for the commencement of any medical treatment which patient gives. And without such consent, the treatment of the patient would constitute a trespass and the battery. Many the foreign judgments have discussed this trespass and battery in this context. And patient has every right to refuse his consent, and he should be adult and sound mind. We'll see the ingredients of consent also. There are different types of consent. I don't want to go the different types, but in general, I will say expressed, or it is a verbally given consent, or in the writing also, verbal or writing express consent. And there is one consent. It is the implied consent. It is for the OPD patients. When the patient enters the doctor's chamber, yes, there is one contract, doctor-patient relationship will develop, and it is an implied contract. The patient wants, doctor shall examine me, and the doctor has consented, he will examine the patient. This is the mutual, it is an implied from the patient. Now, next is valid consent, then informed consent and proxy consent. All are interlinked words. So we'll focus on only informed consent today. What is informed consent? Read the line, signature on the dotted lines. The patient's signature goes a long way towards the mitigating the legal problems of the doctor. Remember, this is very important. In the medical record, which we observe in our National Commission or in the any court of any courts, the most of the medical records, they are missing, either missing. If there is a surgery, consent is taken just a casual manner. It is just nothing was mentioned. Consent forms are blank. Also, we have seen no name of the patient, no name of the doctor. Sometimes which surgery you are performing, that is missing. The anesthetist consent is also missing. So these are the very crucial points which court will look into before deciding the case against the doctor. So make sure that the consent was informed. For anesthetist, the pre-anesthetic checkup is very important. You will examine the patient, the past history and then the assessment, and you'll do several assessment, investigations, ECG, and then now the question whether it is your duty as an anesthetist to explain which operation is going to be happen. There are controversial views. Yes, anesthetist also should tell this operation is going to happen on you, and I will administer this type of anesthesia. And there are other questions. The anesthetist role is only limited for the anesthesia. He should explain. Primary duty of the anesthetist is to explain the drug reactions, mode of anesthesia, then the complications and alternatives of anesthesia. And finally, you have to explain, yes, laparotomy or laparoscopy will be performed, because many times what happens, if you say laparoscopy, and the surgery went on laparotomy, that time the conflict will start. The anesthetist told me this thing and doctor performed this thing. So there will be tussle between surgeon, operating surgeon and the doctor. So be very specific. If you know which operation is going on, at which time, and you have to mention and you have to sign the document with the time mentioned on it. Then what are the contents of informed consent? We say informed consent, many judgments are coming from the Honorable Supreme Court, the National Commission, and from the world courts, various courts in the world. So what is the, what it means literally? The degree of disclosure should be, there should be reasonable disclosure, then adequate disclosure and complete disclosure. What are these three terms? You may know in 2015, the UK court has decided the Montgomery's case. You can note this, Montgomery, you can Google and find out. The Montgomery's case, it has elaborated all the issues of the consent. So it says you have to explain the rarest possibility of the complications also. What injury will suffer by your act, you have to explain the patient, and that is valid consent. And so the concept of reasonable disclosure and adequate disclosure is now, it is not valid now. The entire, you have to disclose complete disclosure of the adverse reaction, whatever it is, you have to disclose. That is a valid consent after Montgomery. How detailed should be consent be? Now, how detailed consent should be? That is, the patient or attendant should able to make judicious decision based on the information shared by the doctor or the member of the treating team. Now see, the judicial decision of the patient. What is the judicial decision of the patient? First thing, you have to look whether the patient is adult. Yes, if he is adult, then no problem. If he is a minor or unsound mind, his guardians, parents, or whatever the attendants, near close attendants, you can take the consent from them. Now, you have to explain, the doctor has to explain what you are going to do. And then let him take the decision. Yes, I want this surgery. I don't want this procedure. I want only this minimal this thing. Suppose I told also there is a right to refuse the consent. If the patient refuses the consent, you have to record that. You cannot say he refused and so the operation was terminated, or we have not taken further operation. But your notes, clinical notes should mention the refusal also. Refusal of the consent should be recorded. It is valid in the law. Then the second part is the information shared by the doctor or the member of treating team. Now, who will take the consent? Who will take the consent? Whether treating surgeon or the nurse or the duty doctor or the resident, who will take the consent? See, the member of the treating team. The junior resident or senior resident is not a treating team. The patient has come to the hospital, to the consultant on his name that some XYZ will operate me. That person should take the consent. It is the legally, that is the valid consent, valid informed consent. The person who operates, he should take the consent. Then the second part, the member of the treating team. Yes, the associate surgeon, if it is there, he is the assisting surgeon. If he takes the consent, explaining all the details that so and so doctor will perform the operation, I will be assisting the operation and operation of the procedure, and these are the different issues in this your disease and treatment aspect. So that is again valid consent. But no sister, no staff or any junior doctor if he goes to the patient's bed and take the sign on the dotted line or the blank paper, it is not a valid consent. Yes, I have summarized here what is informed consent. It is remember the word brand. It is very important. It covers entire thing. It is the benefits of the treatment. So doctor should explain the benefits of the treatment, the risk of the treatment, then the alternatives. What are the alternatives? Suppose if you won't go for this, suppose there is a surgery, angiography is showing triple vessel disease, frank triple vessel disease, and 80 to 90% all the arteries are blocked. Now, patient is harping on do this plasty or anything. But it is your duty, the CABG is the proper treatment in this case. Suppose there is just a simple abdominal pain. The surgeon suspect appendicitis, but the patient will say, Dr. Saab, you operate me. I am getting repeated pain. But it is your duty to examine and tell him the alternatives. We have to go conservative for 15 days or 20 days. The investigations are like this, and this operation is suitable. Suppose I will come to again cardiac case. If the CAG is showing minimal blocks and other things, and if there are, what are the different alternatives? You can treat the patient by medicines, by angioplasty, or by CABG also. So you have to put all the alternatives. Yes, these are the alternatives. This is the best. Now you decide whatever you, but you have to record what he says. You have to record, means record in writing. Preferably, if he writes, it is well and good. Then again, doctor, it has the duty of the treating surgeon or doctor to tell whether there is a treatment is there or not. Suppose there is a frank case of malignancy, metastasis or anything. Yes, it is the duty. Yes, you will not survive. There is no need of operation. That is, you have to tell that. If there is no treatment at all, suppose congenital anomalies are there and there is no remedy now, then you have to tell there is no further treatment. You have to bear with this thing. And the last is very important, the documentation and signature. Whatever you have told, that should be documented. Now, the question is the documentation. Whether the documentation should be in the writing, in the doctor's handwriting, or writing in the patient's handwriting, or whether electronic mode document is valid, or whether it is a printed document is valid. Now I will come to that. So the documentation plus signature, I will discuss documentation again. The documentation and signature is very essential. The document should be signed by the patient if he is alert, adult, and not intoxicated. He can sign. Then the doctor, the treating doctor or the team of the surgeon, team of the doctors, he should sign that with the time and the date, and with the two independent witnesses from either one from the patient side and one from the hospital or doctor side. Now the question, witnesses, suppose there is no witness. If it is a planned surgery, there are definitely some witnesses, somebody of the family will be there. But if there is an emergency, if the patient has brought in the emergency accident or head injury, then there is no need of any consent. You proceed to treat the patient. Honorable Supreme Court also of the view, first treat the emergency, then the law will set in the motion. That time, the doctor will not be held responsible why you have not taken the consent. The prime duty is to save the patient. You can refer the Parmanand Qatar's case and the T.T. Thomas case, T.T. Thomas and Elijah case, you can refer. So the landmark decisions I have quoted here, the Samira Kohli's case, you can go through, and the Montgomery, this is a very recent case from the UK court. Samira Kohli's judgment is from India, and it is very wonderful. It has given all the details of ingredients of informed consent. Then what happens before us in the court of law, or where I deliver the speech also, many times the doctor or hospital take the defense that, oh, it is our usual practice or invariable practice that we take the consent on the printed form. This is not correct. The consent forms field in general as a risk have been discussed, and the patient had an opportunity to ask the questions. It should reflect that your consent form should reflect that you have discussed everything and the patient was given proper opportunity to ask the question. And many times this is lacking in all many of 80% of the consent forms which we go through, and that's why the penalty of the on the doctor or hospital will be there. However, the actual risk discussed, see this sentence, the actual risk discussed are not documented on the consent form. Okay, I say no doctor will harm the patient, but this is the drawback amongst the medical fraternity. Whatever they explain, whatever they discuss with the patient, they never document in the consent form. But they will write, I have explained everything to the patient. This is wrong. You can't say that I have explained everything to patient. What everything? You write, yes, I have explained there will be bleeding, there will be embolism, there will be so and so, there will be drug reaction, whatever it is. It is your duty to explain and document that. Or either in the consent form or anywhere in your case sheet, you write that consent was taken, explain these following risks to the patient. Now, I want to give the take-home message that avoid errors. But before that, I will tell whether the document, I was telling in the previous slide, the documentation of the consent is necessary. How? Whether in your writing or patient's writing or somebody's writing or electronic mode or the printed. Now there is a lot of confusion. Many times doctor fraternity, the medical fraternity asks me whether the printed stationaries are banned. No, that is wrong notion. Printed stationaries are not banned, but blanket consent, if the printed stationery won't defect, the details of the proper surgery, it should be specific to the branch of the surgery or specific to the consent form, printed consent form should be specific to the specific disease and specific branch. It should not be generalized. You cannot generalize the form where you can put anything and that will be a valid consent. So I will not go into detail, but you should understand if it is if it is the abdominal surgery, the consent form should be for the abdominal surgery. That consent form shall not be used for orthopedic surgery. You cannot just, hello? You cannot use such consent form as a generalized consent form. Remember. Now, avoid errors. Yes, this is very important for all the fraternity who are linked with the consent. Never consider a procedure too trivial or a consent or take a blanket consent. Remember, there is no. As far as I know, my professor, when I graduated in Sholapur, my professor of surgery told there is no such a thing in surgery that minor or major surgery. All the surgery, all the invasive procedures are, there is no distinction minor or major. Take all surgeries are important. Don't distinguish minor or major. So don't think that I am doing just incision and drainage. There is no need of consent. But while doing incision and drainage, you will give local anesthesia, and the anesthetic reaction may be there, and anything may happen. Anaphylactic reaction may be there. So don't consider any procedure too trivial. Many times what happens, there is a pleural effusion, and clinically you can, the physician or the surgeon will see that there is a pleural effusion. Yes, we will do the tapping. He will take in the emergency room and he tries to tap the pleural fluid, and accidentally the spleen will be punctured. Now, what is here? He has not taken the consent. No, come, just come. It is a very simple procedure. I will put the needle. Yes, every court also knows it is a simple procedure. You have not taken the consent, you have not investigated the patient, you have not done ultrasound to assess from where I should put the needle. If there is ultrasound facility in your hospital, why you are lagging behind? Clinically, you are suspecting there is pleural effusion. You have seen the X-ray, but do the ultrasound where I should put, or do the ultrasound guided aspiration. If there is a minimal pleural effusion, how will you put the needle? So remember, these are very crucial issues, and don't think every procedure is trivial one. And don't take a blanket consent. Consent should be procedure specific. I told it should be procedure specific. Either it is printed or it is handwritten. The printed consent should it deemed to be, or it should appear as an informed consent for that specific procedure. The courts are not against the printed consent, but the printed consent should be procedure specific. You explain. If it is orthopedic surgery, explain there is embolism or non-union, malunion, infection, whatever it is. If it is a seizure, you explain the amniotic fluid embolism, PPH, or death of the child, whatever it is. I am not expert in that. So the consent should be very specific. The patient is competent, see, sound mind, and not intoxicated or a minor. Remember this thing. Using terminologies and language that patient does not understand or comprehend. If the patient is from village, if you say some hi-fi word, definitely he will not understand. So you tell, the operation will be performed on your this thing, and the appendix will be removed, and this is the thing. Then the stitches are put. The chances of infection, whatever it is, you should tell in his language. Preferably, if you don't know his language, call your staff or anyone who knows. Then make it easy. It is how you will tackle it is your outlook. Now that not having a witness when the patient is minor. So avoid the errors, not having a witness. If the patient is minor or intoxicated or unconscious, if there is no witness, don't go blindly. Okay, I will take the consent later on. This is not permissible. And lastly, don't delegate the duty of taking informed consent to junior staff. Yes, I told it is the responsibility of the operating surgeon. The master of ship is responsible for all the things which goes wrong. So don't delegate the duty of taking informed consent to any of the junior staff. Either he is the doctor or the staff nurse. This you can refer the judgment. Chinal versus Toms. It is the UK judgment. This is US judgment. Recently in 2017 decided. So. So documentation is very important. Patient information sheet. What is documentation now? The information sheet is given. It should be signed by the signed and properly dated by you and the patient also. This document is very important because patients will ask the documents to while at the time of discharge. Now remember the medical record. It is again controversy. Medical record is the property of the patient. Remember this. Whether I am wrong or right, but take it that medical record is the property of the patient. You cannot retain the medical record. You can retain either Xerox or original, but he should be provided medical record within 72 hours if he demands, as per NCI. Or if you don't want any headache, hand over the medical records at the time of discharge, because the limitation period is for 2 years and patient can come anytime to ask the record when you are busy. Then the consent for re-exploration, repeat of the procedure, and the blood transfusion is mandatory. Yes, suppose you suspect something infected or something happened. At the time of hysterectomy, ureters are cut. The patient will show anuria. Then definitely the operating surgeon or gynecologist will notice there is no urine in the urine passed by the patient. So you need to re-explore. Don't keep hidden or concealed from the patient or any relative. Take the consent for re-exploration. Explain them this. We have to check again. Then the re-exploration or repeat the procedure. Many times FNAC or any biopsies, the tissue is not coming. That time you have to repeat the procedure, tell the and take the consent while repeat procedure. Then the blood transfusion, it is mandatory. Then the alteration to the consent form have to be authorized by the patient. Remember, if you have missed something in the explaining the consent form, and later on, if you come to know, yes, I would have explained this to the patient, but that should be authorized by the patient. You cannot, because this is the electronic era. Whatever you write, whatever you put on the record, whatever you ink on the record, it will be taken within a second. When you turn your back, you will take the photograph, the message will go throughout the world through the WhatsApp. So don't think that if I change these words, it has not gone anywhere. It is your luck if the patient has not taken anything. But now in this electronic era, everyone is very, very intelligent. Remember, the consent is not a defense for the professional negligence. Remember this. Even if you have taken the consent, everything is fine. But there is a professional negligence. It is the domain of MCI and other things. I'm not going into that. It is not a defense for professional negligence. So thank you very much that have tried my level best to cover up many issues. Consent is very vast topic and it needs hours together to discuss. But lastly, I want to tell my friends, colleagues, the delegates that for the consent, informed consent is very evolving, and every courts are very minutely and meticulously viewing the consent. Secondly, you go through our Indian judgment. Samira Kohli's judgment is very good. You access to the Google, then Montgomery's judgment, and the evolution of consent, the Canterbury judgment, the Sidaway's judgment, you will go through and prepare your consent in such a way that everything should contain there. Don't be a generalized form. And I hope if any questions, you can ask the panelists, because I'm maybe busy in some other. I have to attend some meeting now. So my professor is there. The learned audience, the doctors, the panelists are very good. And thank you very much for the invite. And any suggestions you can send me. I'll try to explain it. Thank you.
Thank you, Dr. Kantikar. But I'll request you to stay behind because there are lots of questions for you. I've been noting on a piece of paper.
I have free assignment and I'm very sorry. I could not. I have to go now at 11:30. Okay.
So if then, because the questions which have come, before I go to the medical legal issues, I'll put these questions straight forward to you then. You can stop sharing the screen, and the questions which are pertinent are loud and clear. First one is printed consent. There was a recent judgment which you were a very part of it.
I'm very sorry that I am not ready to discuss that judgment because it is authored by me and I won't think it is wise on my part. You can discuss the thing. I have explained in my talk. Everything I have explained.
Okay, sir. For the benefit of the House, I must say that there was a recent judgment about the printed thing that they are illegal. It is nothing sort of that. You can read that judgment in detail.
Sorry, I can't discuss, and I'm very sorry.
No, it's not for you, sir. Because there were lots of questions in the chat box.
Well, you discuss among your panel and let the panel decide. You have many. You can file the review. You can go to Supreme Court also.
Okay, sir. What is your comment on video consent and telephonic consent?
Yes, video consent and telephonic consent. It is not video consent. If you record in your clinic before that is the very good defense that will prove your bona fide. And but the written consent is very important. Whatever you write, that is valid because videos can be tampered also. But written consent is must in every.
Okay, and
telephonic consent is not valid. It amounts to as good as delegating the consent to some other. It is not valid.
How to bring the independent witness to court of law who was witness to the consent?
So you can request the court. He was the witness, and court will summon him. If you remember the witness address and other thing, then you file an application to the court. He was the witness. Call him.
Okay, sir. And usually, I am working in a medical college. There is a patient stay file, and this is opinion which I am seeking from you. There is a 2-page of printed consent which mentions about anesthesia risk also and surgical risk also, and we add on to the additional risks for a particular procedure like pyelolithotomy, that it can be covered from percutaneous to open pyelolithotomy if there is a risk, and we are giving some spinal anesthesia. We also write that if required, it can be covered under general anesthesia also. But both the 2 pages, we fill the name of the, it is a 2 pages printed in the file, but we fill the blank columns, the name, CR number, age, diagnosis, procedure, address, signature of the witness, signature of the patient, and signature of the doctor. So, are we doing a right practice?
No, it is correct. You have explained whether the procedure, different alternatives, you have explained what is wrong in that. I won't
Right.
think wrong.
Right, sir. So I am.
And it may be converted into general anesthesia. Many times it happens, but there should be mention about this. Many times it won't happen that the doctor will say, I have explained verbally and it was emergency, so I changed it to general anesthesia. That is not allowed.
Right. And one question was that in Indian scenario, talking about reasonable, adequate, complete disclosure and talking about rarest of rare complications, discussions. Yes, it is. I am a son of lawyer and I understand the legalities. You are a doctor also and you are into legal bent also. But explaining the patient's rarest of rare complications, how much is practical in Indian scenario?
See, what you see, whether practically you will see or you want future headache for you, because protecting your skin is main important. And telling your rarest complications. Okay, what is rarest? You will die.
Yes, sir.
What is the rarest? You should tell you will die in this procedure also. Not explaining that you will die, what purpose it will serve. You explain, you will lose one patient. Losing one patient is better than headache from that patient throughout the life.
Right, sir. Dr. Mulidhar Joshi, you like to say something, sir? Please go ahead.
I think sir, it was a very nice listening to you and also Dr. Ashok, and a lot of other things are there because we have to understand at this point of time. Sir, how about video consent? Like you had some reservation of video consent. We'll be taking the like handwritten. But whatever, sometimes there will be 3-4 attendants will be there. Somebody will sign and somebody will come when the patient has a problem. If you have video consent, 4-5 of them sitting there, explain to them everything and explain to them, like, you know, it's like going to
Video consent is for that. Video consent will prove that you have taken the consent. But the contents of the consents are not there.
No, we will take a written question here. Is if, for example, even if I do, for example, a test dose for some medication, there are times that somebody who has the same medication earlier, the test dose again can induce a severe anaphylactic reaction.
Yes.
Right? Right?
Test dose, giving the test dose.
Pathologist, you know it very well. Why I'm trying to say all these things is, antibiotic test dose we give, somebody who is sensitized might end up with a severe anaphylaxis. It has happened. We keep seeing in the like anesthetic, like pre-op area. But as our honorary secretary, Dr. Naveen, rightly expressed, how much to disclose? That every procedure has a risk, including a trigger point injection. Patient, like I said, pleural effusion tapping, patient might collapse. Say, for example, one thing you will write. Say, for example, on every printed version, do you want to take like death can be one of the final result? Do you want to take that one?
See, the law mandates. We can't go beyond the law. The law mandates you should give all the information. Now you want to bypass the things, then law will say why you have bypassed. Suppose I am driving the vehicle without the license. License is, but without driving the vehicle without license on the road is the offense. You have everything, but law mandates the license should be in your pocket. Here, the law mandates consent should be
The pocket.
in the
But
so better to avoid such.
no, you are right, sir. But what I'm trying to say is, every day if I miss 30, 40 surgeries as part of the team member, for every surgery which are might go minor, there's nothing like minor surgery, major surgery. There are minor surgeons or probably major surgeons. Surgeries are nothing minor and not even anything. So the people who have died, like you must in internship doing, taking like an injection for penicillin, also people have died, collapsed. You know it. What is my fear is, in this way, we are scaring the general practitioners to run away from the practice, and the like neighborhood clinics are going off, a small nursing home. That's my fear. Not a bigger hospital.
Now you request the Honorable Supreme Court to look into this matter.
No, fair enough, sir. You can guide us.
I don't want to say you bypass the law. I will
Sir,
say this is the law.
We want your suggestion. What is our concern? Is it right or wrong? First of all, you think our concern is right or wrong? Like, neighborhood clinics might disappear.
You cannot take that I am busy, that's why I have not taken consent. I have hundreds patients, I have not case. You restrict one patient. You complete the formalities, go ahead. Because law has said you take consent. Suppose for blood transfusion.
One thing I was really happy about what you said, sir. I should appreciate you, Dr. Karthikar, sir. Any patient walking into an outpatient is automatically implied consent. Am I right?
Yes, it is implied.
As compared to general practitioners also?
Yes, it is implied consent. But if you are giving injection, see, the patient cannot say he examined me without my consent. Because when you entered in his clinic, yes, he will put the stetho, everything. Tomorrow he will not say that without my consent he examined. But he will definitely say without my consent he gave the injection. You say this is a penicillin or this is B complex, you make it the giddiness or headache, or you may collapse also, you tell. And just tell it. Or write in that prescription, explain the consent and giddiness and other things, that's all. Because courts are not against doctor. They will see the situation at that time. Suppose for the blood transfusion, the question came before me. I have handled 2 blood banks, and the drug controller asked me, we have transfused, the patient was in CCF, pregnant lady in CCF. And here we can't transfuse whole blood, and we have to give pack cell. I was the medical director of that blood bank, and they asked me, doctor, the hospital requested me, just give us pack cell because it is overloaded, CCF. That's why then I told them, okay, we'll remove the plasma and we'll give. And unfortunately, that time some drug inspector came, and how you are preparing this thing when you have no license. We have to face a lot of from the drug controller department. Then I asked the drug controller, if the patient is, and if she is dying and it is a contraindicated, then if I remove the plasma and I have supplied to the blood bank, to the hospital, and the patient saved, what wrong I have committed? Then he only said, sir, this Drug and Control Act, it says that if you have no license, you should not do fractionation. He was stuck on that. So remember, we are with the law, but if you are doing with bona fide, record that because of this, but you cannot take defense, I am busy and other. So thank you very much. I am getting the call now. Thank you.
So congratulations, sir, for coming to us and talking about the brand, the benefits of treatment, risks of treatment, alternatives to be explained, no treatment option also, and documentation and signature. Thank you very much for sparing your time, and we'll interact with you in near future also. Thank you very much.
Sir, Dr. Venkat Giri, thank you.
So now it's my proud pleasure to introduce Dr. Sunila Sharma, our next
I
speaker.
hope Ashok sir will be available for us.
Dr. Patil will stay with us.
Yes.
He will be there. And this is the topic which our anesthesiologist colleagues are waiting. And I know we are slightly behind the schedule, but Dr. Sunila Sharma is ex-director of anesthesiology, pain medicine and perioperative care at Fortis Hospital, Vasant Kunj, Delhi, and Park Hospital, Gurgaon. And she is expert in legal matters pertaining to anesthesiology, and she has been a chairperson of legal cell of ISA Delhi State Branch also, and she has done her hospital education also, published a book on law and the doctor, and she has been awarded numerous awards. So ma'am, over to you to talk about the medico-legal issues pertaining to anesthesiology. And I know all my ISN friends are eager to listen to you, though we are running late of time. Dr. Sunila Sharma, madam. You can share your slides, madam.
Thank you. So I'll be presenting the medico-legal aspects of anesthesia practice. Can you see me by any chance? Or
We can see you, but you have to share your slides.
My slides, I have opened them.
And go to the bottom button of share screen.
Okay, I think we'll put it, I did that. Oh my God. I never thought I was all set for it and it has gone into the other mode. Wait.
Dr. Patil, by the time, madam, I'll utilize that time. Dr. Patil, can you please switch on your video?
I want to go for share screen because
Yes,
I can
yes,
see the.
Yes, doctor. Share screen.
Now I can see it now. Zoom meeting, I can see.
On the
There
bottom.
is share screen, yeah.
Click it.
Here is my micro. So these are my slides. So
click on that particular slide. Click on that particular presentation.
So
Bharat,
can you
please guide us.
Can you see it now? Because
No, doctor.
You need to click on share screen before that.
I had taken. That's what I'm saying because I did share screen. Here
You
is
need
again.
to
This is
swipe
the share screen. Yeah.
Share screen, and then a pop-up will come, and you need to click on share again.
Pop, share again. Okay.
Yeah. Now, yes. Yes.
Now
yes.
I can take into the
Slideshow mode.
the slide mode. Yeah.
Madam, Dr. Sunila, it's not a share screen, it's a Sharni ka screen.
Sharni ka screen. Okay.
थक गए हैं, थोड़ा बहुत break ले लेंगे. Please go ahead.
Madam.
ठीक है. So now you can see my screen, I suppose so.
Yes, madam.
It is on medical legal aspects of anesthesia practice. And we all being anesthesiologists, we know that there are different types of places where the anesthesiologists work in. It could be a nursing home based or an institution based. And there are differences in the infrastructure, policies and practices everywhere. And they are, anesthesiologists have been traditionally known for having very limited interactions with patients at times, but with the law evolving and with the Consumer Protection Act and all those coming, that interactions have increased definitely with time. But there are also demands in the choice of the type of anesthesia that a patient wants and even in the personnel who administer it. So being anesthesiologists, again, we know that it's a complex branch of anesthesia that we practice. And there's an interaction between man, machine, and environment in this, in our environment. So there are a lot of issues which occur in anybody's lifetime, or either it happens with them or with others. So we are dealing with the airway protection. We are dealing with prevention of hypoxia, which is very, very important by checking your anesthesia machine and oxygen supply. We have to really supervise the patients very well. Have also thermal burns have occurred, and we have to protect the patient. Medication errors, we have to really know that we don't do that. And definitely if something happens as a complication during the operation, we have to do crisis management. So we'll discussing about the duty of care, right from the pre-anesthetic checkup to preoperative preparations, arrangement of the blood wherever it is indicated, consent, which has to be informed, and look at our, coming to OT, don't depend just on the technicians, but also see that the oxygen supply is there, connected, central supply, and we have all the drugs and equipment. And remember, there have been cases of defibrillator not available inside the OTs. So see that you have a working apparatus there. And then finally, perioperative care. So pre-anesthetic checkup, I'm talking to the anesthetist, I presume. We are doing patient interview. And that is the time when you can really understand their problems that they might be suffering from. We talk to the family if they have some person along with them, looking at asking for the anesthesia problems, their medication history, any previous anesthetic problems. We examine them properly. This is the time to build a rapport also with the patient and look at the diagnostic data, their reports, assign them a status, and formulate an anesthetic plan there and discuss about it in the presence of the relatives. That is the best thing to do, and also documentation of the risk at the same time. That is the pre-anesthetic checkup part itself. The informed patient consent process. Normally, we see that in most of the hospitals, it is left to the nurses to do it, and doctors may not be doing it themselves. But it is a good idea to do it personally while the relatives are around and take the informed consent. And we know that the signatures of the physician who discloses the information also means consent, the patient, and even the witnesses who could be basically related witnesses are much better. But suppose there is only one attendant there, we can take it from a neighbor bed attendant also. But it is much better to be taken from the other people than the hospital staff, the nurses signing it or anybody else signing it as a witness. And we must talk in the language that the patient understands, and or the interpreter is involved, and document this fact. Now, coming to some medical legal aspects, informed consent forces the doctor to give the patient the knowledge that will make him or her an equal bargaining partner. And this consent transforms the essence of the doctor-patient relationship to a contractual one. So consent is a contract for services. This is an agreement which is enforceable by law under Section 13 of the Indian Contract Act. Now, we have a system of pre-printed consent forms, and there are certain essentials, like, as you see here, in addition to whatever is written for almost every form, there should be some place where you can really make the additions yourself in your writing. So, filling of these blanks, name of the patient, relationship, the techniques or procedures in simple language, a doctor who is taking consent, and remember the doctor, I would prefer, because this is what was my practice, we would go and take the consent ourselves and even review it in the preoperative area and talk to the relatives and correct or get it again if there were some discrepancies. We write about the comorbid diseases that are mentioned in the consent form itself, the nature and purpose of the technique, that anesthetic technique that's going to be used, and the possible alternative methods of treatment with the risks involved. So the risks, we know anything can happen and it is not predictable most of the times. But yes, we do tick in certain things which we know can happen. So it's not a blanket consent, but yes, we do tick which has got more likely incidents. Coming to the types of anesthetic mishaps, being anesthesiologists, we all know they could be airway related because of the difficult airway. There may be inability to intubate or ventilate. Yes, if you are not cautious enough, remember, by slippage of endotracheal tube because of disconnections or going inside, causing oxygen desaturation. Pneumothorax by doing certain procedures, invasive procedures that we do for central venous pressure insertion, line insertions. gastric aspiration when we are really not really sure that patient is fasting, or in an emergency we take it. We got to mention it in our reports whether the patient is empty stomach. We look at all the cardiac aspects and the things that might happen inside the operation theater. Hypotension is common if there's a massive blood loss. We have to be prepared for such things, with even the blood transfusions be booked by the blood bank. And cardiac arrest and hypoxic brain surgery are the most issues we all know. Human patient safety, even a small breach which you find that it is very easy to anesthetize, and especially the postgraduate, you will even see them with the books, reading their books while anesthetizing a patient. So this is one of the examples of breaching the patient safety. They can be patient factors in very little person, depending on the comorbidities that they suffer from. But there can be systemic failures, and the systemic failures also include leaving your case on a technician and going out for a tea or a coffee, instead of leaving on a person who is an anesthetist and you are sure that they'll monitor well and not distract. Well, we know that a patient's safety gets compromised by certain mishaps, and mishaps may cause no harm or may cause near miss events, but we have to be very careful because they can happen with anybody. So when we look at the anesthetic incidents, there are preventable incidents and they are the human errors. Because whether it's an emergency, because it is the whole night working, especially in government institutions, there had been emergencies, so many emergencies. Yes, the with the equipment or specific surgical procedures, and lack of skilled assistance. But remember, vigilance is very important. Inadequate vigilance can always give you a lot of problems. There can be breathing circuit disconnection, as I said. There may be inadvertent changes in the gas flow. Drug syringe errors, not labeling your drugs or giving an overdosage, sleep deprivation, probably whole night working. These incidents can occur. And remember, the inadequate communication amongst the personnel who are present, the communication should be very strong. So if they're inadequate, you may cause more incidents. Distraction causes inadequate vigilance and monitoring failure. We have seen people who, after anesthetizing, feel so relaxed that they are either reading a novel or doing something else, or even now in today's day, playing with the telephone things, and they're busier looking at their telephones than on the monitor screens. These are monitor failing we are facing with the advent of new equipment. Well, equipment failures do form 14% of this. But deaths on table, though they are very uncertain deaths, and I think in our own life we might have seen one or two near death experience, or probably almost reaching a severe hypotensive thing with severe bradycardia. We got to be very careful about this while they're monitoring. Do we declare a death on the table? Well, over the time we learned it's better to revive the patient, even if you have to put in a pacemaker, do whatever it is, take them to the ICU, put them on the monitors, and probably we learned through the experiences that death should not be declared on the table. That's why people put even pacemakers during that, even if it is near death or some acute event has taken place. Because if you declare a death on the table, it becomes a police case, and autopsy definitely will be ordered if the cause of death is uncertain. Now, as we look at the changing interrelationships between medicine and law, whatever procedures we do, there is a some law relationship. Like when we do a pre-anesthetic checkup, this is the time when doctor-patient relationship is built. There is a dialogue between the patient and the anesthesiologist, and definitely it changes the stance from paternalistic to whatever I do or what I enter to the legal ones. We get the consent form filled after having talked about the whole procedure, about listing the side effects and getting its signatures right in the, we used to do it in the OPD itself, but it has to be, even if it's not done in the OPD, either going on the bedside in the presence of the relatives and then taking informed consent there, or if even that has not been happened and the patient has come as a daycare in the preoperative area, always the interaction with relatives helps. So in law, it is a contract for services that we are going to render to the patient. Now, for the choice of technique, we are all aware that there are two legal principles, Bolam principle and the Polito principle. Bolam principle means that what the technique that everyone uses for that particular procedure. Now, Bolam actually meant was for an electroconvulsive therapy. The case was related to that, where there were two opinions whether the therapy should be by using the relaxant drugs or only sedation. So that was the principle, but it is for the doctor to really, who is anesthetizing, to decide which he would like to do, and such should have to be discussed pre-anesthetic discussion has to take place with the patient and the patient relatives. Then the Polito principle is where what treatment that you would give to the patient. The Polito principle actually came from the case of a child who was operated for patent ductus arteriosus and was admitted with acute croup. The question arose whether he should have been put on the ventilator or it was all right that it would have been put on the oxygen. But the child had collapsed and had a cardiac arrest followed by severe brain damage. But it was said that doctor was negligent for not attending to the child. The issue that whether he should have been intubated and averted, which would have averted his collapse, was that there were people who said that they would have observed the child if something like that happened, they would have ventilated. The other said, yes, it could have been they could have ventilated. So Polito's principle actually, again, that is, his doctor is not negligent if he uses another method, if he's taking care and observing. The defibrillator has to be present around within the OT complex, and if it's not there and the patient dies because of that not getting the treatment, it is a medical liability and it is definitely negligent. The complications have to be managed, even if you need to call different physicians, the cardiologists, whosoever, you have to manage then and that and document it. This is important because that is a legal proof. In a cesarean, in a placenta previa cases, if the blood is not available and it has not been arranged and patient bleeds to death, that's a medical liability too. The post-operative follow-up has to be done because omissions by the staff or doctor, omission of the doctor to come and see the patient is a legal liability. Now, three types of situations occur when the court cases come. The allegations of negligence may be made only against the anesthesiologist. Allegation may name both the surgeons and anesthesiologists to get better remuneration or better returns after the case. And allegations may also involve the hospital where the mishap occurred along with the doctors. Now, hospital does have a vicarious liability for the negligence of staff. Surgeon is vicarious liable for the anesthesiologist if the surgeon has selected the anesthesiologist himself or called a special anesthesiologist for his case. But if the patient selects anesthesiologist, then surgeon is not responsible, but I don't think most of the cases patient does not get a chance to select his anesthesiologist. And if anesthesiologist's name is written in the consent form and patient signs it, that is also presumed that patient has read who will be the anesthesiologist, and definitely there is a liability of that anesthesiologist. Coming to the legal allegations that have come against anesthesiologists, whether it's in India or abroad, is one, failure to properly instruct the patients prior to anesthesia for limiting food or liquid intake. Failure to administer oxygen during surgery or properly monitor the patient. Using defective medical devices and equipment during anesthetic administration. Again, administering too much of anesthesia if they find that the recovery is delayed, administering too little of anesthetic drugs if patient is awake and can recall the intraoperative events. And also, the patient may be allergic and that still an incorrect anesthesia drug has been given. Probably somebody else did a pre-anesthesia checkup, the other didn't notice or whatever it is. But yes, this is one of the legal allegations and inadequate consent, because this is very important. The person who's going to anesthetize should go and see the patient either preoperatively in the ward, or even if it is in the preoperative area, introduce himself or herself to the patient and patient relatives, because consent by somebody else doing the case conducted by some other anesthetist, definitely that can cause problems. So the legal considerations normally occur. They look at when the cases come to for the there are complaints, legal complaints made. They look at the preoperative assessment, whether it was adequate. Again, how was the informed consent? The proof of which is the proof of discussion. Whether there was noting of the probability of risk of injury that actually has occurred to the patient. What were the qualifications of the anesthesiologist? Was he adequately trained and knowledgeable, or did he need supervision? Was there some carelessness or error of judgment on the point of anesthesiologists? Remember the importance of protocols. They always look at, the legal perspective is, were the recommending protocols followed to manage crisis situation? Could some other steps be taken to prevent this injury? And then there comes the expert witness's opinion, and the quantum of compensation is decided by the courts. Coming to standards of care, we all know that the anesthesiologists have a duty of care. They have to be competent, appropriately experienced, compassionate. They should adequate clinical evaluation of the patient pre-operatively, again, because it's important, even though they have seen them in the preoperative area, if anything has changed. So, decision about providing service, non-discrimination in the patients. They must practice with competence, and whenever the referral of patients, if they have given the referral of the patients, see that those referrals have been attended to, and there is some case summary in that from the specialist. If you delegate duties to the residents, the accountability is for the person who is either senior consultant posted to that person, or even the head of department. Medical documentation is very, very important. It should be always checked before finally sending the patient to the ward. And maintain knowledge and competency. Go on increasing your competency by undertaking certain, say, attending conferences and other advancements. You can take more, I would say, courses and attending the conferences also. Now coming to a few cases, is the verbal consent enough? I think now is the time for just documentation and documentation. There was a patient who went for thyroid surgery. That was long back, somewhere in 1992. And the verbal consent was there. She suffered from, after anesthesia, a massive cerebral vascular accident. She had cerebral edema and she died. The allegation in the course was that the consent was not taken. But when the law, the legal aspects, when they were looked at, patient had come to the hospital with a referral letter. She had waited in the preoperative room with the relatives. The blood was arranged. So they said, yes, they knew that the patient was going to get that surgery. The case was dismissed. That was one of the cases which was, as early as 1992 that I could get. The documentations are very, very important to be complete. And if there's any case going wrong, it is much better that before that the medical records are kept separately and not available. The record should be either photocopied or taken by permission, or even the photographs. Even now that as we are photographing our records, we have seen even the relatives photographing the case sheets on the nurses' stations. So remember, everybody is getting there, starting it right from the pre-operative time. So the documentation, our pre-anesthetic checkup should not be done in a way that, it has vacant places, not fully filled. Junior most person doing it, there has to be always reviewed by a senior person to see that there are no lacunae. The discussion of the anesthetic plan with the patient, the relatives is very important. And if the senior who is going to be with the senior goes and discusses this thing, it matters a lot. And definitely it gives them solace when they look at the senior person along with the junior person. The pre-anesthetic record has to be very neat, very competently done. And that is going to be a documentation which is going to come for reassessment when the things go wrong. So we know the intraoperative anesthesia chart as we record vitals and ventilatory parameters, the drugs and the gas flow. And wherever any deviation from the normal occurs, or any side effect or any problem has occurred during anesthesia, the time and the action taken has to be documented over the case sheet. So we have to document even the communication processes in the doctor's notes, the events, differential diagnosis, management, investigations. If the patient has died and the post-mortem has to be done, the request should be there with final summary of the case. This is the good documentation which can serve as evidence that the process indeed take place. No risks. We are very shy. Most of us are shy of disclosing the risk that we will frighten away the patient from getting the surgery done. Even the surgeons would probably give very half knowledge, They don't want to frighten or lose those patients at times. There are two legal standards. One is the reasonable practitioner standard. That means you disclose those risks that will be disclosed by a reasonable practitioner in the relevant specialty. This occurs both in British, as we do form British type of practice, and India. Reasonable patient standard is tougher. Here, the dictum is that to disclose those materials that a reasonable patient would need to know to make an informed decision. Even in USA, they do like this, and even in India. You don't want to frighten away your patient. So you're giving a reasonable material risk where you are telling. But remember, do talk to the relatives and give them details of what can go wrong in such and such patients. With blood transfusions, there have been legal cases, wrong blood transfused, consent of blood transfusion not taken. And this was a State Consumer Redressal Commission of Mumbai, where 5,20,000 compensation was ordered. Blood has to be available when you are anticipating blood loss in cesarean, postpartum hemorrhage. And if exsanguination causes death, remember the courts have said that it is preventable by taking advanced precaution and diligence. In this case, in Gujarat, in 1997, court had awarded 2,35,000 to the complainant. There was another case of paralysis after spinal anesthesia. We use spinal anesthesia day in, day out, but there was a time, when the local anesthetic glass ampules were sterilized from outside in phenol. Those ampules were kept in the phenol solution. Now, 2 middle-aged men develop persistent paralysis below waist after that spinal anesthetic. But the court still decided that the doctors were not negligent, as this risk was not appreciated by an ordinary competent anesthesiologist in 1947 when this occurred. Practice at the time of incidence is considered and not at the time of trial. So even though this was now after that you must have seen that the putting the glass ampoules in the solution of phenol was abandoned. There's another case of lignocaine sensitivity when after spinal anesthesia there was a cardiac arrest. There have been cases when the anesthetists have been held guilty because after having cardiac arrest, the patient was transferred to a distant nursing home, or the doctor gave spinal anesthesia in spite of patient's apprehensions. Those cases, the doctors were held guilty. They were not held guilty even when lignocaine sensitivity test was not done because of the literature proof that the allergic reaction due to lignocaine is 1 in lakh. And negative result does not ensure safety, and it is documentations and our literature proof which helps us to come out of such situations. Having a defibrillator around you is important. It may be not available in your own OT room, but it has to be present in the operation theatre complex. There was a young man who underwent surgery for correction of deformity of arm. He had been operated previously also for the same arm for the injury sustained after an accident. Before the second operation, he was referred to the cardiologist. ECG was taken and the patient was declared fit. Intraoperatively, the patient had cardiac arrest and died after 1 hour. Well, the allegations were no proper monitoring, and also the worst thing was the negligence was held because defibrillator was not available in operation theatre. Another case, biopsy of growth in throat under general anesthesia done without putting in an endotracheal tube until after the patient developed difficulty in breathing. This patient died on the OT table. This case was of 2005 when the first appeal was done. In 2007, it was decided. The state commission held deficiency in the service on the part of the anesthesiologist because required procedure for administration of anesthesia in upper respiratory tract obstruction was not followed. They did not put in an endotracheal tube. The compensation of 2 lakh was awarded to the complainant, who was the wife of the deceased. The National Commission, the doctors approached National Commission, but that upheld the order of the State Commission and dismissed the appeal by the doctors. Again, with the observation, nothing had been appointed by the doctors to establish that there was no negligence or deficiency in service in administered anesthesia. Aspiration of gastric contents when the patient is full stomach, obese. Well, in this case, there was anesthetists faced difficulty in endotracheal intubation during induction because of obesity and absence of teeth. Patient aspirated. But in this case in 1990, patient was not held liable. In second case, the patient was held liable because patient underwent an elective surgery for hernia under general anesthesia and aspirated during extubation. She was reintubated, treated, but expired. Both the surgeon and anesthetist were held liable for not having prepared the patient well before an elective operation. In dental anesthesia, there have been cases of overdose of anesthesia, where the lignocaine injection is more than 4 times of the recommended dose, along with other high dose of meprivocaine. This was in 1995. And in this case, Mr. Stewart was convicted of manslaughter. His name was struck off the register by the General Dental Council, and he was given a 9-month prison sentence and a suspension for 1 year. So vigilance and attention judgment errors, they are triggered by interaction of the patient and the equipment. And we know that there are reasons that can contribute to accidents. They can be disorderly personal routines, disorganized workspace ergonomics, faulty and intermittent charting, or breakdown in the system of checks and balances. Another case, failed intubation, patient followed protocol, and that's why not health negligent. He did the anesthetist failed 2 attempts on intubation, but followed the recommended drill of failed intubation, calls for help, continued oxygenation, and allowed the patient to wake up. The patient sued the hospital authority. So witnesses gave evidence that the defendant's drill, which the anesthesiologist followed, was used in a number of well-known London hospitals, as well as in Sweden and Holland, and patient was not held negligent. Another case, the recovery room staff, there were certain omissions. 10-year-old child underwent correction of ears, prominent ears, and a general anesthetic. The nurses, 3 out of the 5 nurses went for coffee, and child was not observed for about 25 minutes. And when one of the nurses examined him after returning from coffee, found him cyanosed with no vital signs. Patient had suffered cardiac arrest, had irreparable brain damage, and died 5 years later without regaining consciousness. His personal representatives pursued proceedings against the anesthetist and the hospital proprietor, and definitely they were awarded compensations. So coming to the legal part of it, prerequisites for liability. An error of judgment in itself does not amount to negligence. But for liability, we look at the doctor-patient relationship, whether the harm was foreseeable by the doctor, the duty of care performed by the doctor who anesthetized, and the harm that has occurred. The hospital does have a vicarious liability or a primary liability, depending on the number of staff that are in the OT. If there's always a deficit of people, and an anesthesiologist is managing 2 OTs, or one OT with a technician and the other one. So this is, the hospital becomes vicarious liable. Supervision again, it becomes a vicarious liability. And equipment, whether the equipment is adequate or not, is important. Now, in the legal parlor, we are looking at the doctor-patient relationship. Traditionally, it has been a paternalistic society, and the trust was there on the doctor, and it was the doctor who decided what was best for the patient, even if in cases a certain treatment or full disclosure might harm the patient. This was initially when the doctor-patient were on unequal bargaining terms, because doctor special knowledge created the advantage. But now with the doctor-patient relationship change with the modern times, because of privatization, competition in practice and price, underplaying of risk of complications, patients' increased access to information on the web, and rising financial burden, the doctor-patient relationship has definitely deteriorated. But the courts say there is still no criminal liability. This practice was curbed by the landmark judgment in Supreme Court of India in Dr. Suresh Gupta's case, when a death occurred during plastic surgery on the nose and patient had blood aspiration. All the precautions, the endotracheal tube was in place and all the precautions were taken. Still, no criminal liability was given. The courts that have come up over the time, they are consumer courts, they are civil courts of jurisdiction. Well, they have the period of limitation when the patient can, within which the patient party can file a complaint. There is discovery of some fact later, and that can be entertained. And there are expert witnesses who attend the courts to fight the case. Can we just forward it now faster?
Yes, ma'am.
Yeah. So medical records are very important. They should be created, and they should not be, really done in haste by the judicial person. We know that the law is on us. It came that it's in 1986 when the Consumer Protection Act came, and this we were all put, the doctors were put under law of torts. We have the state councils also, but criminals, the Supreme Court of India said that doctors can't be liable for criminal charges if a patient dies due to an error of judgment. So we know that there in law of negligence, there are duties that we must do, duty of care, duty of looking at the patients, and if there is injury due to some breach of duty, there are compensation has to be paid. That's why we have insurances now helping us. So there are compensation, and even the professional licenses are taken depending the standard of care. So standard of care is very important. A doctor must maintain that standard of care which is expected out of them. If something happens inside the operation theater, the onus of proof lies on the doctors and not on the patient. Normally, it is the patient who has to prove that the doctor is negligent. And if there are certain things which fall under the recips are located at the thing, it is evident that there was the negligence of the doctor is when the wrong patient is operated and a wrong surgery is done, taking the elective case without pre-anesthetic checkup clearance, not recognizing extubation intraoperatively, patient burns on the table, improper patient padding, and inadequate eye protection causing eye injuration. So law recognizes that medical treatment is full of risk and desired outcome may not be achieved, but there's a standard of care which is expected from anesthesiologists, and it is higher than every practitioner. Any technique patient may use, again, there are Boehm's principle and the Polito principle, whether there's a different view. Any choice depends on these two principles. This Boehm principle was that whatever practice accepted as proper by the responsible body of men has to be done, even that body takes a different view. It was a case of electroconvulsive therapy without muscle relaxants and suffered fractures, and there was another group who said that the muscle fraction should be given. But when there are two ways of doing things, it is not for the courts to decide which one is right. It is the professional body who decides. And in Polito principle, it came when a 2-year-old suffered catastrophic brain damage as a result of cardiac arrest induced by respiratory failure. So the patient was not properly examined preoperatively. So when we come to the legal pass, it is for the complainant to show that there was the existence of duty of care, there was deficient duty of care, and the resultant damage occurred. But when the events occurred inside the OT, there's an intraoperative death on the table, or probably there's a major complication. The onus falls upon the doctors to prove that there was no negligence. Expert opinions are always sought by the police and courts, and definitely affidavits and expert medical witnesses are there, along with having a post-mortem report to prove what went wrong. If you are sued, well, you have to hire your own lawyer. Take the records of the anesthesia chart. Do not make any changes in the records, and do prepare your defense, looking at the medical references and favorably decided court cases. Remember, your anesthetic documentation that you did will come to your rescue if you've done it properly and monitored and noted all the intraoperative adverse events. Expert witness will always help you. So I close by saying that we all know that our branch is a human intensive branch. We are specialists, so law does expect a higher standard of care from us. Locality rule is not applicable to specialists, and the duties that we owe, the medical duties in tort, contract, and duty to explain, we must all follow. Documentation is the proof for what we did, and expert witness testimony does carry weightage during the trials. So we must keep on updating our knowledge and skills regularly, use essential checklists, preoperatively reassess our patients, document well, maintain continuity of care, and refrain from providing casual telephonic or verbal advice. Keep on updating our skills and knowledge to match the prevalent standard of care at any time. So we look at our guidelines, processes, and practices and stay with them. Institutions are also held vicarious liable for shortcomings in their infrastructure. And thank you for giving me an opportunity to talk about this subject.
Thank you, madam, for this talk on medical legal issues pertaining to anesthesia. You can stop sharing your screen now. And I know our panelists are there with us. And Dr. Patil, thank you for staying back. I know I'll have some very quick questions coming up in the pop box. You can unmute yourself, sir. The most important question is the $1 million question. Is the healthcare excluded or not in the new provisions of CPA?
One word, no.
No. So all said and done, the health services are still under the purview of CPA. Sir, there is a provision that earlier it was district courts, and you have very well said that that has been changed, that the complainant, whether he is residing or in the area of gain. Does that mean that the doctor will have to go here and there for the cases?
This is not a new thing. Even in other legislation also, they have made where the person is residing, a matrimonial case or labor case. In many legislation, it has already made. So here now, under this act, it has made. And now, if the people are very busy, then there is another provision, video conferencing, that can be used.
Okay, so the lawyer who represents the doctor or the doctor or the experts, they can give witness through a video conference.
Yeah.
So there is earlier it was that suppose a case is settled against you and you want to appeal, you have to file a 50% compensation granted by the lower court. Earlier there was a limit and of the 25,000, and also the limit of the district court has been raised up to 1 CR. So these are the new provisions. Can you re-highlight them?
Yeah, I told in my PPT also. Yes, 1 crore it is increased the pecuniary jurisdiction, but now this time they are saying only on the basis of consideration paid. Earlier, claim was on the basis of total compensation. Now it is on the basis of what you have paid. On that basis, the pecuniary jurisdiction will be decided. And that's why they have increased the pecuniary jurisdiction. And now in future, lot of consumer forums, commissions should be established depending on number of cases. There will be a flood of cases to the district forum only than state commission. That's the first thing. Second thing, we have seen, lot of cases for small amount, people are going up to Supreme Court, National Commission and Supreme Court without any genuine reasons. And that's why in a deterrent way, if there is a genuine case, then only people will file an appeal. Otherwise, they will not file an appeal. And whatever amount they are depositing in the appellate court, that is refundable if the person or institution wins the case. So only for the purpose of deterrence, if there is a genuine, then only they should file. Otherwise, they should not file. So that is the purpose behind this change. Earlier also, it was not only 25,000 or 50%, whichever is lesser. Now they have increased to 50,000 and value also increased. See, that was 86. Now we are in 2019. The amount is also lot of things. Earlier we used to get goods for 10 rupees, now for 100 rupees. So value also increased. Because of that reason, they have increased.
Sir, suppose the health service provider goes to the appellant authority and wins the case. Is there any interest payable on the amount deposited, the 50% of the compensation?
As on now, that is not disclosed anywhere, but 50% of the amount, it will come back, but the interest, that is not clear.
Not clear.
Yeah. Yeah.
Suppose both the parties are aggrieved. A low district court gives a compensation of suppose 10 lakhs. The health service providers think that it is too high, and the appellant and the patient think that it is too low. and both goes to the court of higher authority, patient also has to deposit 50%?
See, one has to go to court. One has to, anyone, both will not at a time file a complaint. Complainant or opposite party, whosoever goes first, that case will be filed. And this deposit is only for the opposite party, not for the complainant.
So that means health hospital.
Yeah.
Or whosoever goes first. Well, if patient goes first, then sir?
No deposit.
Okay, only for the hospital.
Court fee and whatever other things are there, they have to pay.
Only for the hospital. Okay, sir. I am working in a medical college, and there the treatment is free of charge for everybody. So does Consumer Protection Act applies?
Sir, I appreciate Sunila Sharma madam's the presentation. Lot of things covered. So for your question, answer is VP Shanta case.
Right,
Clearly,
sir.
they have mentioned you are 100% charity. No. If you are partly you are charging, partly you are not charging free, then yes, together.
Right, sir. Right, sir. The specific question was that in our hospital, this is a practical scenario, we charge only 5 rupees for an OPD card, which also is formed, but so that patients do not lose. We don't want to earn. Suppose they spend 5 rupees for an OPD card or 5 rupees for a CR slip, they do not lose that way. So that is a charity.
Here again, it depends on a lot of facts of the case. Usually hospitals, whosoever runs the hospital along with the medical college, lot of facts will changes. So here I'm clearly telling you one hospital which is 100% charity, like government hospital. It will not cover under Consumer Protection Act.
Right,
But if there is a negligence, anyway, civil court is there to get a justice. Yeah.
Yes, sir. Yes, sir. Achha. Second thing was mediation settlement. Right, settlement by mediation or out of court settlement. There is no appeal. Whatever that committee decides, you cannot go to the higher authority against that.
Okay. See, first of all, we should know what is mediation. Mediation is a voluntary process. Mediation is a voluntary process. Both parties must agree for mediation process. And even though both parties have agreed for mediation, but later stage, if opposite party feels that it is not reasonable, they can come out from the mediation. Or complainant, if they feel that mediation is not happening properly, they can, that person also come out from the mediation. It is not settled forcibly on both the parties. If both parties happily signs the document, then only mediation settlement. Otherwise, there is no mediation settlement. If it is not settled, then the mediator submits report to the court, commission, and commission it will take its original procedure.
Sir, I am really thankful to you for answering these questions. These are all questions which are come in chat box, more than 100. I just briefed them. So thank you for answering them. One doctor has asked, what is the eligibility to become member of district committee, district forum?
See, now lot of people, I mean, just a 35 years age and any degree holder can become a district consumer forum commission member. And there was earlier a lot of the problem that the salary was just 40,000, 50,000 per month. Now, because of the new rules, lot of changes. The class 1 officers' salary is fixed. Then all the perks, all the vehicle facilities, government officers' salary is fixed for 4 years. So it's a very attractive one. So everybody should come forward and join.
Right, sir. Can a hospital file a complaint against a patient on non-payment of bills?
See, only consumer section is defined who is a consumer. So if a hospital falls under that consumer definition, yes. But hospital will not fall under that consumer definition, because consumer definition says whosoever purchases goods, hires a service for consideration. So hence the hospital will not be considered as a complainant. So they have to go to civil court.
Right, sir. Thank you very much. And I'll give you a break. Dr. Rajan Sharma is also here. Dr. Rajan Sharma, can you please unmute yourself? And by the time Dr. Rajan Sharma comes, Madam Dr. Sunila Sharma, there were numerous plastic surgeons and other specialty doctors also in our panel today, in our audience today. And they have asked very clearly about this confusion regarding applicability of Samira Kohli judgment and about the consent, whether it still holds true, because they said one of the message was there that it says that till the parliament passes the law or Supreme Court settles otherwise. So can you slightly clarify on that?
Look, until that particular law is passed, the previous law stands. That is what I would say. There has to be, a modification, amendment, which is made public or put into the legal books. I think this was since it pertained to the doctor, that's why I came to it. I don't know what exactly happened after that, after the decision. But I wouldn't be able to, that person to judge it. I think it's the lawyers who will be able to tell us that more.
Right. And Dr. Rajan Sharma, whenever you please unmute yourself. The next question for you, Dr. Sunila Sharma, was that, Dr. Rajan Sharma, you are there. Unmute yourself, sir. You are muted. Sir, you are muted. Unmute yourself, sir. Unmute. Yeah. We heard Dr. Rajan Sharma, Dr. Kantikar also about the informed consent, and Dr. Patil also. So as of now, he is very clear that health services are not excluded from CPA. So what are the recommendations made by IMA to the government regarding exclusion of health services in the CPA, sir?
See, Naveen, just give me 1 minute. Hello.
Yes, sir.
As far as IMA is concerned, we are seized of the matter, and see, now the thing is, first of all, we were excluded as healthcare services were excluded in a cabinet note in the last session, on the last day of the last government's first term, and we are out of it. But yes, I 100% endorse the point that legal Supreme Court judgment stands. So now IMA's line of thinking is to go two ways. One, to keep on pestering the government and see if we can get some favorable legislations. And in the meanwhile, we have already issued instructions to all our state presidents and secretaries that we are keeping a tab on all the consumer court cases. As of now, before coming here, my parallel meeting was to in-house close discussion on CPA, how to go and strategize. Legal opinions have been taken, and we are now collecting cases so that collectively any big case which is coming across the country, we can fight it with IMA's active contribution to it and to help our member. And then see all options available, including legal remedies, will be given a consideration. But yes, we also live in an era that consumers, patients' right will have to be kept in mind. So an alternative mechanism out of the consumer courts has to be given a thought. And IMA would request everybody to be on board so that we all fight it collectively rather than going separate ways.
So are you planning to call a multidisciplinary meeting on this?
Yeah. We have a federation of other medical associations. We have been a part of it before. I think by Monday, Tuesday, next week we'll be calling it.
And you talked about twofold strategy. One was Supreme Court, and other was liaising with the government authorities. So how far we have gone there, sir?
I have already started it. So some details, let them be there. But IMA is seized of the matter, and I think, let's see.
Okay. You are also a private practitioner, sir. You are practicing in a city and doing an independent orthopedic practice. As a doctor, God forbidding, something happens in a nursing home in a particular city. And usually the thing is that the police comes. And the doctors usually get afraid of it. But there are numerous judgments that a criminal case, and Madam Sunila Sharma also has clearly said that criminal cases cannot be directly filed. So for the benefit of our audience, you please highlight on that?
See, as far as the first thing is empowering of the healthcare violence, we are actively considering, and hopefully it should be incorporated in various state acts, because as of now, 23 states have incorporated this healthcare violence against doctors. As far as filing of criminal cases against doctors is absolutely wrong under no law. And sometimes it was being done by political pressure, but I'm glad to share wherever doctors have taken it up actively, we have not seen these cases. Like I'm from my hometown. We are very proactive in our approach that hardly violence, we are violence free since past 5 years, except for 1 or 2 incidents, but handled by police very effectively. And till date, no criminal case. But yes, other part of the town, there are some places, and wherever we can, we should see. At the end of the day, we have to empower ourselves fully.
Right. So that means if there is something happening, we should know that there is a provision that a maximum civil complaint can be filed, which will be looked by the civil surgeon office, by a committee of 3 doctors, and that will decide whether there is some negligence or not.
We have a mediation cell here also.
Yes. Okay. Dr. Sunila Sharma, one question for you. I'll give a breather to Dr. Rajan Sharma and Dr. Patil for 1 minute. Death on table, should it be declared on table or in ICU?
I would say it has to be declared in ICU. Otherwise, you are putting yourself into more trouble. Because we have had certain things, we have seen them in our lives. You take them on ventilator, on the tube, put it in the ICU. People have it put in the
tracking system.
People have
that we have for drug trials can be inbuilt in this structure also.
Yeah. No problem. Please go ahead, madam.
Yeah, because we make all the efforts to resuscitate. We have put in the pacemakers, and and then transfer the patient with the ventilator, with pacemakers, everything in defibrillated and all to the ICU, but not declared on the OT. No, it has to be really seen, put there, and then slowly the news have to go. The death in the ICU. That is the experience that we have had over 50 years of our work. I think never do it on the table. No.
Right, ma'am. Right. Dr. Mulidhar Joshi, sir, please, if you can, there's a question coming up, rather a comment and a request.
For our last few minutes from your call,
There's a comment in the chat box. ISA should form a standard PAC, standard consent form pertaining to anesthesia, and standard anesthesia record sheet for whole of the country.
Yeah, Raveen, I'll be happy to share that particular thing. That's not a problem at all, because that's a very small thing. But I just, before I express anything, I just want to speak to Dr. Ashok sir. Ashok sir, are you there? Can you hear me?
Yeah.
Sir, I just want to understand, sir, 70% of healthcare in India is from private sector. Yes or no? 70%, 30% government. 30% government sector. Sir, Dr. Rajan, what do you say? Rajan?
Yeah, 70% is in private sector, sir. Agreed.
That means 70% doctors in the country are exposed for whatever the Consumer Protection Act. Nothing wrong about that. I'm not saying. If you even take 1 rupee from any patient, I'm answerable, sir. Ashok sir, yes or no?
See, my answer is all manufacturers, all service providers are exposed, not only the health service sector. So it is common for everybody, not only for health sector.
So the moment we charge even 1 rupee or 10 rupee, we are answerable to the consumer. Am I right?
Yeah.
So second thing, sir, I also want to understand from you that the two, three things. One thing is Dr. Kantikar sir also said about if you're not carrying your driving license in your pocket, so any police officer can ask you, the traffic police person, where is your driving license? But sometimes what can happen, because sometimes when we are maybe private sector 70%, we say because we are charging patient something, we also get something to record their statements or video with their consultation opinion. Where does the video consultation, like for example, if I can invest, even if I'm earning 1,000 rupees per day, if I want to invest on a video consultation along with written consent, is it okay, or you feel video consent is still not okay?
Sir, let me clarify some of the basic things. I'm not a doctor, but since 2008, I'm in touch with hospitals, doctors, ethical committees of NIMANS. I worked as a legal expert in NIMANS ethics committee, many hospitals, and I have interacted with many experts and public, mainly public. See, day by day, as Sunila Madam said, that trust is coming down. Trust between the patient and doctor. Doctors are so busy, they are even not getting time to coolly discuss with the patient. See, not in general OPD type of thing, but mainly the way the cases come, surgery, whatever you have given example, in those cases, it's a very rare cases. The 1 rupee, 2 rupee, they also knows, patient also knows that you are putting very less charges, all those things. But majority of the cases, see, all hospitals are not bad, all doctors are not bad. First of all, majority are good, but there are people, there are hospitals who are violating the things and exploiting. Because of those people, the bad name is coming to the whole community. So that's why self-regulation, or within your home, if you make it very strictly, then a lot of problems can be solved. That's the first thing. And maybe everybody throughout India, throughout the world, have seen one of the Amir Khan's episode, Satyameva Jayate. Everybody's seen. And even IMA chairman was there, Devi Shetty was there, all famous international doctors were there, patients were there, everybody with the proof. Amir Khan explained what is happening. So everybody knows, public knows what is happening in some area, some corner. So we cannot blindly, yes, we have to take care of that, but majority of the people are very good. But unless you control those people who are doing or exploiting the consumers or the patients, bad name comes to good people also. So that's why my request is self-regulation within yourself. If you control, then a lot of problems will be solved. Another one is just you think of within your associations like ombudsman, the ombudsman for your sector. Just like insurance ombudsman, banking ombudsmans are there. So there should be a legal sanctity for that. You can establish that. A lot of cases will be reduced going to the court. And another thing, why? Because the patients are going to the court because there is no proper transparent interaction between the hospital or doctor with the patients in majority of the cases. For every general rule, there is an exception. Even after explaining everything, there are people, they go. We cannot argue or discuss on those exceptional things. But majority of the people, if you convince the patient, yes, I did, if they convince that doctor has done well, but badly, it's my bad luck or the case is like that, we cannot succeed. If that feeling comes, nobody will go to court. And other now option is mediation. Option is with you. Even doctors can undergo mediation course. Now private institutions are running mediation course. if you are, anybody cannot become a mediator. It's a skill one must have. You have to understand the patient's mindset, that particular doctor's mindset, facts. Then you have to neutralize them and try to settle them. So you can concentrate on mediation process also within the hospital, or at the district commission or state commission, national commission. You try, if it is reasonable, go for settlement. Otherwise, anyway, commissions are there. And other aspects, I'm in touch with the IRDAI, Insurance Regulatory Development Authority. There was a consumer committee which established a policyholders website in 1999-2000. During that time, throughout the India, experts were there, doctors were there. What is happening in health insurance? That also many people knows. So that's why there are some loopholes. You fill that gap, then automatically there is no fear of new legislation. But you try your level best within your reach. But the present settled law is covered. Nobody is excluded. That is my statement, sir.
So only one clarification I want to have. How about having combination of the print consent and also audio-visual? Is it okay? Is it better? More evidence is more safe. Print version consent.
See,
on paper and audio-visual also simultaneously.
See, even whatever we are doing online or teleconferencing, basic documents we are keeping. When that computer will crash or document will lose, safer side, the hard copy should be there along with additional support purpose video documentation. If it is there, then altogether it shows complete protection. And another thing, usually it's my personal experience, many people experience who have observed in hospitals, whatever the day-to-day, whatever happens, there is very less communication between the patient relatives with the doctors. Maybe sometimes nurse will speak, but doctors will not speak because their time is valuable just to come and do and go. But again, there are exceptions, there are good doctors. But because of this particular thing, that particular trust or gap is increasing. That's why all these types of things are happening. Even for small things, people are going because of that gap.
Dr. Ashok, I fully agree with you, but I'll tell you the biggest problem, because I'm in private sector for last more than 25 years. A doctor life is normally at least 30 years, and 25 years I'm already there. But I'm telling you what happens, that the day one which the attendant is there, he's not there on day 3. He's not there on day 7, and he's not on day 10. So you speak to attendant 1 on day 1, and there will be attendant 3 on day 3, and there will be attendant 8 on day 7, and it goes on. So this is where I was talking audiovisual, because the first impact, if the 10 people sitting there, let's counsel all of them together. What's wrong with having audiovisual aid? Alternate them were there on day 0, and every day with whom sir we are talking, we record audiovisual aid, because we don't know who is he. He says, I'm his cousin. Every day the doctor cannot. If he's seeing at least 20 patients in hospital, he can, whether it's his cousin or brother. How do we document as a doctor? Who is he? I don't know. He says, I'm his attendant. His wife is at home, or maybe doctor is not come, or he's in US. I think the best thing is whenever there is any consultation, counseling happens, because this is my private sector experience last 25 years. Every consultation should be on paper and on audio-visual. Anyway, if you're collecting fees, let's invest on collecting on paper and also AV aids that is safe for every medical fraternity.
Yes, I agree with you.
Thank you, sir.
Thank you, Dr. Naveen. I think you got the answer.
Yeah, yes, sir. So, for the benefit of the members, Dr. Giri, please unmute yourself.
I have one question which was asked by somebody. Patients recording this thing, whether it is valid, because many times patients they start recording in the hospital, ICU, and all. What we do that? How much value for that? And now with the mobile, nothing is secret. Whatever it is, they just go on doing. And see, we can't give the confidentiality of the patient or anything. They make it rampant, public, and all. Whatever comes there. How go ahead with that?
You're talking about patient and patient relative recording, or
yes.
Patient relative or somebody, third person also recording and making it viral in the media. See, they put bad name to the hospital. One is patient and his relative. telling that it is not right, that is not right. Second thing is other people recording where they lose the confidentiality. Can they put on the hospital or anything? It is not anything connected to the hospital. Third person. These two things.
See, again, I come to the trust point. So if you have disclosed everything, what is happening day to day, there nobody will go for that particular act. When there is a suspect, then only these people will start doing all these things. And you cannot stop now technology, even camera, small camera they can put. You cannot stop that. So only better way is be transparent, discuss day to day with the patient relative, what is happening, what is the truth. See, always truth is a good defense for anybody, not only doctors. So that's why if you tell the truth, transparent with those people, then even though they record, nothing will happen. And and if they have recorded and what your paper says one thing, record says different thing, then automatically court will consider record also.
Ashok, I just want to have one more thing, because whenever we do video recording of any consultation or counseling and all, we always tell the family members, whosoever is there, attendants and all, like this is for the record purpose. We take a consent from them that we are going to video record all the discussion as long as it's lost. Every day we take. But do they also have to take, or they can just record it like a spy?
Yeah, see how you are saying, they may say in that way. See, ultimately by express, nobody will do that. If they put some, nowadays it's very difficult. Camera, just like a button or pen, any type of things may happen. And only things, another precaution you have to take when you are recording, it is my personal data. If it leaks to the outside, then again, other type of cases will come across. So nowadays, especially even under deficiency service, they have added my personal data shared with any other person without my consent. That is also deficiency in service. If you are recording, that should be under your control. Then everything is safe.
Sir, let me add one more point to this particular thing, what you said, because there was one time a decade back, like in many surgeries were recorded, especially laparoscopy on the video camera and all those things, the CD was handed over to the family members after surgery was over. And the patients were taking objection that one, like, how did you hand over my lap chole surgery to my wife? Because that lap chole also, that the gallbladder was infected and also liver was cirrhotic, and wife said he's cirrhotic because he's alcoholic. So I think recording handover, I'm just suggesting to you, you can alert members also, like we can't record any procedure without taking consent of patient also.
Yeah. See, anyway, CC cameras everywhere in the hospital, entry level, registration level, all those things already there, even in any places. Only thing is where the discussion is happening, that should be there. So yes, see, all these things can be, I'm looking into the broader angle and longer the vision. See, lot of awareness programs happens. I have not seen any doctor coming and giving awareness programs like usually this particular under Legal Services Authority Act. The doctors are going, law college people are going, in NSS camp. So those types of things where if you give awareness, their duties, responsibilities, anyway they are doing, but doctor says, then lot of that gap will be reduced and the relationship will be improved in future.
Thank you, Ashok sir. Naveen, over to you.
Dr. Giri, actually Dr. Giri's question was, Dr. Patil, you talked about confidentiality of services from hospital point of view, healthcare service point of view, but his question was reverse. Does the confidentiality clause only applies to the hospital? What about the patient who's leaking the hospital videos or the video recordings into social media?
See, you can put that particular thing, don't in your application, or don't video or record. That can be done one way. And another thing, wherever illegal things are happening, if they used it, that will be respected, considered. But nothing has happened, but they are sharing unnecessarily. Yes, you can see that why you have shared. You have signed the document that I will not record, I will not share, but you have done that. You can ask the that concerned person who has shared. Somewhere you have to start working on that. But if it is any wrong thing has happened, if he is sharing, if it is proved, then you cannot take any action against that person.
Right. Madam Sunil Sharma, last question for you. I think there have been so many comments. Is the head of the department always responsible for a mishap in his department, whether it is a corporate hospital or it's a medical college? Suppose something happens on a particular table and that was managed by a consultant who is a well qualified MD with a good experience, and there is a head of the department in the medical college or corporate.
Well, in our whole practice, I have never heard that a head of department, yes, is responsible for knowing what went wrong in their department. Yes. Now, in most of the hospitals, they have started those meetings, which get that multidisciplinary meeting with the chairperson and with the head of department and the person who had this mishap. They are recorded. Those things, then, your head of department responsibility gets shared by a particular multidisciplinary team of the hospital. Yes, it is. It is not that the head of department may be called to, he may not be present there. He may be doing another case which was more difficult with somebody else. So may not have really witnessed that. But yes, it has to come to the head of department's knowledge that this thing has happened. That's how we maintain our data in the department itself, and then share it with the quality people and also with the medical superintendent or medical director. So I would say responsibility per law, if he's not, probably is a junior resident or a resident and you have not appointed another one, the supervision deficit, yes, probably you may be implicated for not assigning the proper person for a proper case. That is, I've never seen such case till now when I look into that. Probably the legal people will.
For the clarity of things, if there is a qualified anesthesiologist doing a case, head of the department is not responsible from a medical legal point of view.
Till senior resident, probably people say he's a resident level. The moment the person becomes consultant, they have their independent responsibilities.
So, with the permission, I'd like to conclude. It was an extended session. We were supposed to go by 12:15, but it's already 1:15. And I'm really thankful to Dr. Ashok Patil. He was also supposed to go to another webinar, but he stayed back. And Dr. Kantikar also. And Dr. Rajan Sharma, he was in 3 meetings, so for sparing their valuable time. And I'm thankful to Dr. Muralidhar Joshi, Dr. Venkat Giri, and Dr. Sunila Sharma madam for sharing their inputs. At the end of the day, what all panelists and what Dr. Patil has also re-emphasized is that if intent is good, results are definitely good. And God is always there to take care when you are working with good intent. And all said and done, I read it in 5th class, honesty is best policy. It has been rephrased, refined because of the commercial interests. So people say there are so many commercial angles to it. I have slightly rephrased it. Earlier it was honesty is the best policy. Now it is honesty is still the best policy. So be honest, it is still the best policy. Do any action with good intent. If you commit a mistake, we are all human beings, but it has been done with a good intent, results will definitely be good. Thank you very much. Long live ISA. Jai Hind. Thank you.
Thank you, sir. Thank you.